Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
I just forgot my iPad. Sorry, do you mind grabbing my iPad?
Good morning, everyone. Welcome to the March 10th, 2025 sitting of the Appeals Court. My name is Vicki Henry. I'm your panel chief today, and my pronouns are she, her, and judge. I am delighted to be joined today by Justices Shin on my right and Judge Brennan on my left. And you're welcome to share your pronouns or not, as you see fit. We have 6 cases on the list for today, plus a case that will be on at 2 o'clock. We have 15 minutes per side here in the appeals court, and for better or for worse, no rebuttal. The time is yours to use as you see fit, but I assure you that we have read your materials quite thoroughly, in fact, sometimes more thoroughly than you might have preferred. And so I would encourage you very much to get to the heart of your argument, particularly because we are prone to asking a lot of questions, which I encourage you to think of as a good thing, because it means we are trying to get to the heart of the legal matters. You'll see we all have iPads up here. That's because that's where we have your materials. We are not totally paperless, but we're pretty close. And so we can look, for example, if you refer us to the appendix. And so with that, we'll call our first case this morning, which is 2024 P885, James M. Rodriguez versus MARYNEL, WAHL, and others.
May it please the court. James Rodriguez, the appellant, representing pro se. I think I'd like to start with just a couple of items, and then I have a brief statement, and then I'm anxious to get your questions, and I appreciate your diligence in looking at all the material. I know it's huge. There were 2 issues that seemed to escape the lower court. The first is that there is no stream on the roadway layout. This was determined by the OADR in the final decision.
So, I'm sorry, I didn't hear some words you said. There's no stream on the
roadway layout.
Thank you.
This was determined in the final decision based upon the input and the testimony of the DCR experts, the DEP experts, as well as the commission. And it was consented to by the conservation agent and memorialized in a letter that's currently in the record, known as the Rassman clarification. The other issue is
Can I ask you a quick question? I was a little confused because it seemed at times that folks were talking about different areas of the forest. Am I right or wrong on that, or am I missing something here?
It is a very I won't say confusing, but it is complex in the way that the regulations and the 2 laws mesh. You have jurisdictional issues for the wetlands as far as the DEP and the local commission are concerned. You have jurisdictional issues as far as the forest cutting plan and commercial timber harvesting is concerned. Each has their own regulations. The issue here has been that the DEP required, or there was an enforcement order issued that required attention. And the DEP has an OADR component to hear appeals. That entity determined that I did not need a notice of intent filed, that the land was in agricultural use, and that the area of the roadway was non-jurisdictional. In addition to that, they declared that there were 2 forest stands. The second forest stand was a wetland area, but all of the work that was requested, including the maintenance of the road, was allowed as an agricultural exemption by the OADR.
And that's because there was a forest cutting plan that was in effect at the time.
Do
you agree with that? I mean, I look at the decision by DEP, the final decision, and they concluded that the approval of the FCP was itself sufficient evidence to show that the land was in agricultural use insofar as for the activities that are approved in the plan. But, I mean, there's no dispute that the plan the FCP has expired, right?
Well, that's an interesting question, Your Honor. I appreciate it. There are a number of issues there. There are multiple ways to put land in agricultural use, whether it's through the court, whether it's through a filing. The determination that's made by the DEP on whether land is in agricultural use is predicated on prior history and evidence of how that farm or how that agricultural land was used. The OADR, when they made the determination, the DEP, when they made their recommendation for the negative determination, recognized that the FCP was evidence that the land was presently and primarily growing forest products. That became the basis for, or the definition for, the DEP's term for land and agricultural use. The forest cutting plan itself and the DCR have nothing to do technically with land and agricultural use as a term. The forest cutting plan does define agricultural work, but they don't necessarily define land and agricultural use. That's an area solely for the DEP. There is a memorandum of understanding between the DCR and the DEP. And in that memorandum of understanding, the DEP does cede regulatory authority of wetland areas to the DCR. And they also discuss land and agricultural use. But that's not a function of the forest cutting plan itself per se. It's a function of the DEP collaborating with the DCR in response to.
Right. But you're saying that the previous DEP OADR decision is res judicata now it's res judicata now, right? On the, so that the commission can't issue the enforcement orders. But the previous decision was based on the activities approved in the FCP. So if the FCP is no longer valid, how would the previous decision be res judicata?
Well, I think first of all, I think that there was some news recently given to me from the DEP with respect to the passage of the session laws of 2024, particularly Section 280, which extended all permits and in some cases resurrected all permits that were in effect from January 2023 to January 2024. The DEP is looking into that now, so I can't tell you specifically.
The forest cutting plan is issued by DCR.
It is.
So how could DCP extend? Are you saying DEP is looking to extend the forest cutting plan?
Well, the DEP, as far as I understand it, included the final forest cutting plan and all of the letters into the negative determination.
That's right. But so long as the forest cutting plan is valid.
I think the forest cutting plan was defining work. The only issue that the forest cutting plan comes into play that differs from doing work is whether the work can be done commercially. The work is still the work. The land and agricultural use is still the land and agricultural use. But if the FCP expires, the only ramification is that I can't profit from any timber cutting, which is all that the DCR truly regulates, is commercial timber harvesting.
So is there anything in the record that indicates you had ever started any of the approved forestry work?
There wasn't anything in this record that I didn't get to construct it. I do have Form Fs from 2022 and 2023 of my IRS return that I've supplied to the town's assessor, showing income from the property. The property is now under Chapter 61A. I am required to show annual income, and I did that in 2022 and 2023. It's always intended to be on a small scale, to defray some of the costs associated with the taxes. But it runs hand in hand with the tax exemption for Chapter 61A properties. But I'm required to produce income for 2 years. The land is required to be in agricultural use for 2 years prior to filing for a farm tract ID from the USDA. That was done in 2023. So this property, I believe, is farm number 2519, and I'm anxious to get going with applying for grants from the USDA to do these improvements. As far as I can tell, there are no regulations that I haven't followed, and this is an aberration as far as I'm concerned.
So I want to circle back to the question Judge Brennan asked you. So, and because I might be confused, and we may hear from your opponent here, but I think they're contending that the issues never concerned the whole of Barrel Lane, or the portion of Barrel Lane past the proposed landing area. But they're saying that the concern has been on activity on a different part of Barrel Lane that did include an intermittent stream. So what's your response? Because I understand there's
Right.
tree stand 1 and there's tree stand 2. That part I got. But then,
Well, associated with the forest cutting plan is an access road. It's a requirement under the DCR regulations that you prove you have access to actually get to your cutting stands and your forest landing. There was a situation that arose in the midst of the hearing during the pandemic by a new DCR service forester who claimed to identify a stream running down Barrel Lane. If there were a stream running down Barrel Lane, it would significantly reduce my ability to thin and prune and cut trees within a reasonable buffer area of that stream. He later recognized that the stream was not a regulated stream. That was and there were no filter strips required for the entire length of the road from one end of my property to the other end of my property. So there is no regulated stream in that area.
and is there somewhere that indicates that recognition somewhere in the record?
Yeah, I believe that's in the clarification letter from this DCR service forester. I know it's in, I believe it's in, excuse me, let me just check my notes. Sorry, I don't have my, I don't have a reference to the record appendix. There was a June 9th letter, 2021, from DCR Service Forester myself. I believe it may be record appendix 1, page 9 or page 11.
I have it in front of me. It's Record Appendix 2, page 9.
Page 9. Thank you.
And the DCR forester says there's an intermittent stream that is running down Barrel Lane upstream of the wetland area and therefore does not require a filter strip under the Chapter 132 regulations. What are you saying is the import of that statement?
The import is that if it's not a stream, if it's not a regulated stream under the DCR regulations, it is also not a regulated stream under the DEP regulations because they share the same.
Why would that be?
Because the DCR regulations include and require adherence to the DEP wetlands regulations. I don't have a reference on that either, but it is a part of the 302 CMR 16, I think it's 1604 section that requires, it's in my brief certainly, but it requires that the DCR use DEP definitions. So when the DCR speaks of wetlands, it is the DEP speaking of wetlands. They are the same definitions.
But is the import of this not that, is he not saying that the stream is not within the location of the proposed work in the forest cutting plan? Is that not what this means?
It's more fundamental than that, Your Honor. I think what he's saying is that if he's saying, first of all, he issued a stop work order as a result of his identification of an intermittent stream. When he learned that the intermittent stream did not flow from a wetland or through a wetland, he determined that it was no longer a regulated stream, and as such, he lifted the stop work order and did not require a filter strip, which would allow me to thin additional trees in Forest Stand 2 in the wetland, or along the wetland, or along the road. So the import is his determination, which was consented to by the conservation agent, that it was not a regulated stream, eliminated the potential that there was bordering vegetated wetlands, because there is nothing to border on if there is no regulated stream. So it was profoundly important to what could happen and what could occur on that Forest Stand 2 when that determination was made and recognized by the OADR, the DEP, and the Commission.
That's the end of your time. I'm just checking with my colleagues if they have any further questions. Very well argued, and we'll hear now from your opponent.
Thank you.
May it please the court, my name is Robert Galvin. I represent the Norwell Conservation Commission. I think the appeals court would be benefited by looking at the plan that was attached to the forest cutting plan, which is in the record appendix, volume 1 at page 69. Because that is the plan that everybody has relied upon in determining the scope of the work that was the subject of the forest cutting plan.
So can you tell us what we're looking at when we look at this plan?
And I apologize for the poor quality of it, but this is the best we can do. If you look at the top of the page, because my plan is not across the page, there's a street and a black line coming down from the street, a solid black line, and if you look at the legend, that's called access road. And the access road comes down at a straight angle, adjusts slightly to the left, and then takes a sharp turn into what is a landing area on the plan.
So there are two pins that are relatively near one another?
Correct.
So what is that?
The first pin is the landing area, Your
Okay.
Honor, and then the second pin, I believe, is either stand 1, and then the larger wetland area is stand 2. And Mr. Rodriguez was proposing in his forest cutting plan to clear cut stand 1, and he was proposing to thin and girdle some trees in stand 2. And I had to learn all this terminology because I wasn't familiar with girdling of trees, but essentially it's cutting a strip around the trunk of a tree, which ultimately causes the tree to die, and then it's taken down, and it's part of a forestry process of taking trees down. And
Can I say, and I may be again way off base here,
Yeah.
I hope not. Is this stream or non-stream anywhere on this?
it's not depicted on this plan at all.
And that
You're right.
is your point.
It is my point, Your Honor. The
So
length that you
is he
see
right, though, that there's not a regulated stream?
in the first portion that leads from the main street down to the landing, there is no jurisdictional wetland at all. And that's what the commission has always conceded in this case. The problem is, after you get past that thick black line, which leads to the landing, and you're heading further down this unbuilt roadway, there's an intermittent stream in that area. And
So you're
that's,
talking, so it seems to be HW1?
Correct.
Okay.
That's a bordering vegetated wetland, which is also stand 2. Okay? But just to the left of that, you can see a hollow, thin line. That's the layout of Barrow Lane, an ancient way in the town of Norwell. And you can see how there's no proposed access road in that lower portion of the lane, and that's been the commission's point from the beginning. Mr. Rodriguez unequivocally had permission to cut down anything that he needed to take down to improve the access road in the first portion of the lane leading to the landing. But he never told anybody what he wanted to do with the rest of it.
And what is the work that's the subject of the enforcement orders?
So past the area where the thick black line is, within the layout, the unbuilt layout of Barrow Lane, Mr. Rodriguez began taking trees down and altering a stream channel.
It's literally off the map on what we're looking at.
Correct.
I mean, you have like, so you go past the thick line and there's two little lines that look like a road, and they go for about an inch on or half an inch, and then they just drop off. You're saying it's beyond that?
Yes, Your Honor.
So is there anything in the record that shows that? Where the work you're saying is unlawful is being
I believe there are
performed?
photographs that are probably not great quality.
Is there a
to be-
map or anything, a plot like this? Is it attached to the
I
enforcement
don't believe that
orders?
there's a map, Your Honor, but I do believe that this plan makes it pretty clear what he had authority to do work in and where he did not.
Is that the photo, and I'm looking at Record Appendix 139 with the sort of the mucky, muddy
Yes,
path with tire tracks on it?
Yes, Your
That's
Yes.
what's beyond that
correct.
Boxton area? Okay.
Yes, he brought in heavy equipment, some type of an excavator. I don't know how big it was. He says it's a mini excavator.
Photos.
And he began digging out the roadway, clearing trees, cutting trees, all within the layout of the roadway. This is an ancient roadway. It's probably existed for hundreds of years in the town of Norwell. It was so overgrown that you wouldn't even recognize it as a roadway because the trees that were cut actually in the beginning of the roadway were large mature trees, 75, 100 feet tall. And the commission never took any issue with that. So we think, Your Honors, that this case is dispositive, well, this plan is dispositive of what was specifically permitted. And
Well, so I'm struggling to keep up with you here, but he argues in his reply brief that the Rassman clarification letter, which I think is the one we were all looking at RA2, page 9, identifies only wetland on the property as stand 2 and makes no mention of Barrow Lane as a regulated area. So what do you say to that?
well, Your Honor, the only thing that we were ever talking about was that first segment of the roadway. No one was ever talking about the remainder of the layout of Barrow Lane, other than where he proposed to cut in the forest cutting plan. I have a hard time understanding what Mr. Rassman meant, Your Honor, but I can tell you what the commission understood, and the commission always understood that he had the authority to take down whatever he needed to take down in an upland area, which is the first segment of Barrow Lane. Beyond that, there was never any determination of where the wetland resources were, and we don't believe that that reference by Mr. Rassman has anything to do with the remainder of Barrow Lane beyond the landing area. That's the only way we can rationally understand that, Your Honor. We don't read that as expansively as Mr. Rodriguez does. When you have a forest cutting plan, you're giving it to the DCR service forester, and the DCR service forester, under this memorandum with DEP, determines where the wetland resources are. And this is what we have here. He was only proposing the roadway in, the landing, stand 1 and stand 2. There was no, you can clear the rest of the Barrow Lane wherever you want with impunity. And we think that's pretty clear from the OAR decision that he's obligated to comply with the forest cutting plan. He didn't comply with the forest cutting plan. The forest cutting plan in this particular case expired. I did hear Mr. Rodriguez speak to the Third Permit Extension Act, which isn't anywhere in the briefs, but my understanding is that the Third Permit Extension Act, which is in effect now, has nothing to do with forest cutting plans. They're
Is
specifically
that what you're
excluded.
talking about, when he's referencing 2024, Section 280?
Yes, Your Honors. It would extend an order of conditions or a determination of applicability, but it does not extend forest cutting plans. And
He could apply for a new plan, right?
he was free to apply the day that it expired for a brand-new forest
'Cause
cutting
he didn't have
plan.
much time to do the activities, right? Between the time the appeal was concluded and the expiration.
It was about a year, Your Honor.
So were
October of '22 and the spring of '23, so 6 months, Your Honor.
were you to apply for a new plan, what would be the commission's position as to
If he,
whether he would have to file a notice of intent?
well, if he obtains a new forest cutting plan, the town and the commission has the ability to comment on it. Once it issues, we can appeal it if we chose. But if he gets a forest cutting plan, then he's authorized to perform work in wetland areas strictly in accordance with the new forest cutting plan. And he
So the
does,
previous OADR decision would, if not legally, but
it would be instructive, I believe, Your Honor, as to whether he could resume work, including in new areas, depending on what he showed on the forest cutting plan. So we say the forest cutting plan expired. We said even if it didn't expire, the work that he was performing was well outside the scope of the approved forest cutting plan. In either way, the Superior Court was correct that the commission's decision was supported by the substantial evidence and not based on an error of law. In terms of the res judicata issues, this issue was not actually litigated. It couldn't be litigated because this portion of the property wasn't even an issue in the underlying proceeding. And that's an essential element of res judicata. In terms of the,
So one thing that I was puzzled by is, are you saying that once the forest cutting plan expired, you're not saying he can never get another one?
he has the the commission is not involved in the issuance of a forest cutting plan. He has the absolute right to reapply for a brand new one. He's not precluded in any way, shape, or form from doing that, and if he wanted to work in this area that was beyond the original forest cutting plan, he was free to make application to the service forester to do that. And if the service forester agreed with him, the commission's probably going to be on the short end of the stick if it opposed that, because that provides him the authority to perform forestry work, including in a wetland area.
So he argues the expiration of the forest cutting plan does not change the state of forest growth or the certification of forest land. So I think I know what you say to that, but why don't I hear you say what you say to that?
Sure. On page 27 of my brief, I kind of quoted from the OADR decision. Mr. Rodriguez's land is only in agricultural use and exempt from the Wetlands Act as to those specific activities approved in a forest cutting plan. The failure to comply with the forest cutting plan and the applicable laws triggers numerous enforcement mechanisms to bring the land and activities back into compliance and deter non-compliance in the future. The failure to comply with the wetlands provisions of the forest cutting plan and 302 CMR 16, which is the forest cutting practices regulations, shall void the exemption from Mass General Laws, Chapter 131, Section 40, which is precisely what the commission concluded when it issued its enforcement orders to Mr. Rodriguez.
I guess what I'm trying to understand is, are you saying he has or has not lost any possibility of agricultural use? That's what I'm confused about.
I'm not saying that, Your Honor. He has the absolute right to reapply for a new forest cutting plan, and were he able to obtain one, then his activities would then be exempt as normal maintenance improvement of land in agricultural use. But because his forest cutting plan has expired, he's not sought to renew it, and what he had permission to do never included this area, the commission's decision was sound. The Superior Court was correct in affirming the enforcement orders.
So he says the lower court erred in concluding that he was not growing trees upon forest land.
Your Honors, I would concede that was a strange discussion on the part of the Superior Court judge, but these areas are very technical, and I think that language in her decision didn't make a lot of sense or particular relevance to me. I think she tried hard in a very complex and technical area. I don't know if you noticed the time that took from the time that he initially requested but there were innumerable meetings between DCR and DEP until they could figure out how this should all be interpreted, in particular in this particular case. And they changed their position initially when we were in front of the OADR. Initially, their decision was consistent with ours that he had to file a notice of intent. And midstream, they changed their opinion and said they didn't. And as long as he had a valid forest cutting plan and was doing the work pursuant to that plan, his activities were normal maintenance improvement of land in agricultural use. So they flipped on the commission. The commission tried the case, accepted the judgment, expecting that we would have their assistance in the case of enforcement, which is this posture that we're in right now. The land has never been restored.
Could you explain to me what a forest management plan is?
Sure, that's a different type of a plan than a forest cutting plan. A forest management plan is a approved plan as to how you're going to, and I think they're valid for 10 years. It basically how you're going to grow and regulate various forestry crops in stands on a particular piece of property. I haven't been directly involved in obtaining approval, but I've seen them before. I do not believe that either provides the authority to do work in wetland areas. I think you need the forest cutting plan, and that seems to be the gravamen of the OADR decision and how we view the law here. You still have to have a forest cutting plan, even if you have a forestry management plan. The forestry management plan seems to come in more relevantly to tax classification of properties. If you have a valid forest management plan, you can go to the assessors in a town and get a tax break because you've got land that's in forestry use. And that's how we viewed it in the town of Norwell. It's not an authorization to perform specific work. It's a necessary precondition to having your land gain the protection and special tax classification.
All right, thank you very much. The case is submitted. I think we understand your respective positions. Our second case today is 2024 P964, Department of Children and Families and Another versus Father. I understand there will be a time split on the appellee side of 10 minutes for the first attorney and 5 minutes, that'd be for the department, and 5 minutes for the child. I do know, I think at least one of the parties' briefs mentions the child's first name. We're not doing that here. The case is impounded, so we'll just refer to mother, father, child. And with that, we can begin.
Good morning, Your Honor. Joan Altimore representing the father in this case, Mr. M. Your Honor, at the time of trial in October of 2021, father was incarcerated. So it was quite clear that father was unfit to parent his child at that point in time. The argument that father has is that it was not clear that the indefiniteness of his incarceration would last into, that his incarceration would not mean that he is unfit to a near certitude in the future. There was discussion.
So could we just back up for a minute? What was the state of the record as to the first time father knew he could be the child's father?
And that becomes fairly unclear, Your Honor, in that mother, at the time that the care and protection was filed, mother told the Department of Children and Families that she did not have any idea as to who was parenting the child. There was some evidence that the child had been living with mother and father, but then father became incarcerated. So mother...
Well, in fact, she was living with his parents, right?
She was living with his parents, and I believe later in the testimony that there was some talk that mother and father had been living together with the child with his parents. But mother had initially told DCF first she didn't know who the father was. Then she said that it was a stranger. Then basically she did not identify him. Father did not.
Right, but at some point a family member of father's reached out about possibly being a kin placement, correct?
Correct, Your Honor. And father had been added to the petition not until November of 2020, where it had been filed in 2019. It was after that point in time, and I think close to the trial date, that a paternal family member came forward to DCF and asked for placement.
What was the, if you could just place the timing of the initial conversation between the social worker and the father, where she acknowledges that he gave some indication he was the father?
I'm sorry, that he...
Sure, he indicated that he was the father.
I believe, well, the father got added to the petition in November of 2020.
Right.
And the petition had been filed in, I believe, early 2019.
Yep.
So finally, with the department's recognition that father was actually the father, he got added onto the case. They then produced for him an action plan, which basically consisted of him, pretty much there were two things that he was required to do. One was to engage in substance abuse services, and two, if available, to attend and participate in individual counseling. To his credit, father did sign a release for the Department of Children and Families so that they could speak to his caseworker where he was incarcerated. And the department did, social worker did speak to the caseworker, but there's nothing apparent, I believe, from the court that the social worker ever visited father in person or made continuous visits to the father in person.
Did he ever have visitation with the child prior to the trial? I mean, I was living with the child, but I mean, once the child was removed.
Once the child was removed, Your Honor, no, there was no visitation, and there has continued to be no visitation because the department's position prior to the time of trial was that father, by there being an acknowledgement, if you want to say that, that father was the father by adding him to the petition, but paternity itself had not been established until the last date of trial. There was testimony that a voluntary acknowledgement had been signed by mother and father and mailed to the court, but that was not, the judge did not find that to be credible. So finally, the paternity paperwork, well, actually an adjudication happened at the time of trial, the last day of trial.
Right.
So throughout that entire period, father was not given any visitation. Basically, carrot. Sign the paternity, we'll give you visits. Sign the paternity, we'll give you visits.
Right, but he didn't take the carrot.
He didn't take the carrot, but there is an argument that the department never sent him never sent him the paperwork telling, you can use the argument, telling somebody they should do something versus helping them to do something is two different things.
So part of the issue you were raising is that he was incarcerated, and it seemed clear he was going to be incarcerated for at least 18 months after this trial, right?
There was, at the maximum, it was expected to be 18 months, without knowing what good behavior time he might have accumulated to shorten that period.
Well, that's assuming that the open charges he had were served concurrently, right?
Correct, and that case or cases had not been adjudicated at that point in time. But the expectation was that nobody seemed to dispute was that if he were either to plead or be found guilty, one of the two, that the time would be served concurrently.
Was there, I mean, he had a long history of contact with law enforcement, including multiple drug convictions. Is there any indication, anything you can point us to in the record that this behavior was going to end? I realize the burden of proof is on the department, but could you help us show why this was wrong? No.
No, there is nothing to point to that. I cannot begin to speculate as to, I can argue that he was taking classes while incarcerated on substance abuse, and I'm sure that other work being done in the facility was to try and stop the recidivism, but there was nothing concrete other than the testimony that, the evidence rather, that he had been taking substance abuse classes. He had worked also while incarcerated, he had worked towards his GED under HISET, which the HISET program, so that's evidence that he was trying to better himself, so as when he was released, he could maybe have improve his future. If there are no
I do have a question. I'm just trying to figure out where in the record I can glean that there was some presumption that the assault and battery by means of a dangerous weapon charges that were open at the time would result in concurrent as opposed to consecutive sentences or separate sentences if the case wasn't tried, frankly, until after he got out.
Your Honor, I can't, I'm looking at the transcript. I believe it would have been in father's testimony.
Okay.
Of October 29th, which was the last day of trial. I could look that up and give it to you
Well, that's all.
in
I'll
the future.
find it, but if that's where it is, I'll find it. But it was his testimony. It wasn't as if anybody on the department side
I don't believe
conceded
so.
that or had any information one way or the other on that.
It does not seem like that there was much interest in what father was going to do in the future because of his, at that then time, incarceration. And so, and you know, the argument being that they acknowledged he could be the father, but they felt they could rely upon their position because he was not adjudicated the father. And again, that carrot that he didn't take, but how much, you know, it wasn't the longest carrot,
Right.
put it that way.
So, but there was no finding about this, right?
I don't believe that basically the judge in the finding, I believe the argument was that father was going to be incarcerated into the future.
Okay.
And had been incarcerated at the time of trial. If there are no other questions, then I would rest on my brief.
Thank you very much. We
Thank you.
understand. So we have 10 minutes for the department.
Good morning, and may it please the court. Angelica Duron on behalf of the Department of Children and Families. My pronouns are she, her. We ask that you affirm the juvenile court's judgment. Here, the court had properly concluded on ample, uncontroverted evidence that father had a pattern of criminal behavior, including drug possession, trafficking, and violent offenses, which always led to his incarceration and made him unavailable to parent the child, and that this pattern of behavior would continue into the indefinite future to near certitude, such that terminating his parental rights was in the best interests of the child. Importantly, father concedes unfitness. He has a lengthy history of criminal convictions and charges. Those include possession or trafficking of cocaine, oxycodone, heroin, crack cocaine.
Can you point us to when the father may have first learned he was the father, other than this evidence about where they were living?
Sure. So the judge didn't make the judge said sometime in 2020, he acknowledged that he was the father. I believe in terms of the record, there is an indication that in March of 2020, one of his family members contacted the department to say that he was the father, and that during some time, he, mother, and the child had been living together with one of his family members. But again, there was no finding as to a specific date, nor a specific date where he himself acknowledged that he was the father. We do know that he's added to the care and protection case as a putative father in November. And it takes him well over a year, at least about a year since he's added, and most likely well over a year before he believed himself to be the father, that he files for paternity.
So she argues there's a difference between the department telling him he needs to do something and the department helping him do something. What do you say to that?
Well, the department advised him during the foster care review sessions that they had with with him that he needed to contact the juvenile court, be appointed an attorney, and be adjudicated the legal father. And what's important here is that mother was not forthcoming about who the child's father was. It was unclear what kind of relationship he had with the child, if any. And as the putative father, he wasn't entitled to visitation, right? Establishing paternity is part of action plans that the department imposes on putative fathers, because that is what's relevant to terminating parental rights. You have to have a constitutional right.
This was during the
child.
pandemic.
Yes.
The height of the pandemic. So presumably, and he was incarcerated.
He was incarcerated,
So
correct.
presumably, it would have been quite difficult for him to establish paternity then, right?
Well, he testified that he had mailed in a voluntary acknowledgement of parentage that was lost in the mail, which the judge did not credit. But I think that's an indication that there were means to establish paternity. And again, he had counsel at the time. He had been appointed counsel.
In November.
I think a little later than November. He is appointed an attorney in the care and protection case in February of 2021.
But the prison had restrictions on who could come in and out during the pandemic, right?
I imagine they did. That's not discussed in the record, the extent to which the pandemic affected kind of visitation. But again, this had to do with his willfully failing to establish paternity. There's no testimony that he said it was particularly difficult because of the pandemic. There's nothing that he puts forward to say that there was some kind of failure on the part of the department.
Other than, and I'm not sure it really distinguishes it, but other than the mother's issues that resulted in the department intervening and taking the child, can you tell me what distinguishes this person from virtually every other person who's incarcerated in the state prison or many in the House of Correction? I mean, his record is, it's not great, but it's not the worst I've seen by a long shot. And it seems to me that plenty of folks with much worse records than this have lots of kids that aren't taken, forget the taken part, who's lots of kids where their parental rights are not terminated permanently. So is there something here that distinguishes this father from many others, or is just situationally?
Well, I think, Your Honor, it does not have to be the worst situation for the court to determine that terminating parental rights is in the child's best interest. These were significant crimes. It was also not just drug trafficking, but violent crimes.
Yep. He had
There was
one
a
that looks
history of
like he had a
recidivism.
knife and a gun, and he had a couple of drug cases. But I mean, walk into any district court and many superior courts on any given day, and this guy's record probably is on the lighter side of the menu in terms of the length and the seriousness of records that we see.
But this is Your Honor, this is about his ability and willingness to parent the child, and the judge concluded that he habitually resorted to criminal activity while in the community. Yep.
My question, though, is the reason that we're here is simply, I mean, that's the way it is sometimes, but it's just a set of circumstances where the mother was incapable of caring for the child, and therefore the father's parental rights came into focus and looked at, and I'm not saying that's right or wrong, but...
No, I think the court looks at what father's behavior is, and certainly when determining termination of parental rights, the adoption plan is also considered. It's kind of those two hand in hand, and the adoption...
I guess you anticipated. That seems to me what really is driving this, right, is that you had a potential permanency plan for this child, but for the father kind of being in there, it works, and if he's still around, it doesn't work. Is that fair?
Well, I think...
I'm kind of oversimplifying.
I think, again, it's part of the consideration, but father was going to remain incarcerated at least 18 months, had open charges that from fighting just a month prior to the trial that also led to segregation, which prevented him from engaging in certain services. So I think we can't assume that just because that in the event mother's rights hadn't been terminated, that he would have had, that his wouldn't have been, or that he would have gotten visitation. We can't just assume that on the record.
Are you arguing that the father actually put the child in jeopardy by bringing mom along on the drug dealing?
That was not a finding or conclusion that the judge made. I think it's the fact that, the father had been, it looks like, had some minimal contact with the child, and then was driving around with a substantial amount of drugs in the vehicle with mother, at least speaks to his responsibility that might factor into the judge's determination.
I assume the decree has become final as to the Sister J. Her father didn't appear in the interim.
Yes, Sister J, her father did not appear.
There's
His
no
rights
appeal,
were terminated.
right?
I'm sorry?
There was no appeal
There's
on the
no
docket,
appeal on
and he
that.
didn't, as far as you know, he didn't appear in the interim, so that the decree's become final.
Not as far as I know,
Okay.
but I don't have knowledge of what happened after termination. So again, I just want to emphasize for the court that it's really about the connection between father's history of drug trafficking, his violence, his willful failure to parent the child, and how that bore on the likelihood that he would become fit in the future. And for those reasons, the judge properly concluded that termination of his parental rights and that the adoption plan was in the best interests of the child.
Thank you very much. We'll hear from the attorney for the child.
Thank you.
Good morning, Morgan Russell on behalf of the child. May it please the court, excuse me. The father asked this court to overturn the judgment of the juvenile court based on a hope that the father will improve his parenting and become fit in the future. However, hope is not a course of action. In finding that there is a reasonable likelihood that a parent will become fit, there must be credible evidence to support that. Here, there is none. Father's argument today that the department was dangling a carrot is waived, as it was not raised in the lower court nor in father's argument. I can actually point to testimony by the father at page 407 and 408 of the testimony, where he says that he began co-parenting in June or July of 2019. So I would certainly argue and put forth that father was aware of his parentage as early as June or July of 2019, and despite being arrested with mother in December of 2019 and becoming aware of the child being put in the department's custody, he did not come forward. He did not make himself known to the department. He could have been provided counsel as early as December of 2019, and had he made himself known to the department, he would have been provided counsel. He could have put forth a paternity action much sooner and been provided visitation with his child much sooner.
So what about the questions, though, we were asking? This was at the height of the pandemic, and it may not have been quite as easy as it might be at a different time.
Potentially, but he would have been in contact with the department at the very least. There may have been video visits. He certainly would have had an action plan. He could have had services in place much sooner.
Well, to be clear, is there more involved in the voluntary acknowledgement of paternity than signing a piece of paper?
I'm not sure. They could have had paternity testing done. They could have filed an action for testing. Mm-hmm. There's more than just the signing of a paper. There certainly is.
And I thought that during the pandemic, the DOR agents were not allowed to enter the prisons.
That I don't know. I'm not aware of that, actually. But I would say that even despite all of that, despite knowing his child was in the department's custody, father picked up additional charges after that 2019 arrest, knowing again that his child was in
But
custody.
she says, well, those would have been served concurrently had they been adjudicated. What do you say to that?
That is complete speculation. There's no way to know. And again, there has to be some concrete evidence to show that father, would have found some type of stability. And stability is incredibly important to children. And this child in his pre-adoptive home has that stability. And father has no showing, there's no evidence at all except speculation and hope that maybe someday he could provide his child with that stability.
Well, but her response to that would be the burden was on the department,
To show that father was unstable?
that his unfitness was not temporary.
I think that, the father was incarcerated, and he had pending charges, and he had a history of being in and out of incarceration. That was his entire adulthood. I mean, dating back to 2014, father was only 26 years old, and he had been in and out, and he said, I have a plan to get a job in financial support, but he was working in between his incarceration, so clearly having a job didn't keep him out of incarceration, didn't keep him out of, committing crimes. So what would have changed? Having a high set, what would that have done? He didn't even explain how that would have changed his life. He knew he had a child when he continued to, deal drugs or whatever he was doing. He knew he had a child when he was getting into fights. He knew he had a child when he picked up that gun charge in early 2020. He did it anyway. So what would have changed? And it's unclear from the record what would have changed. There's no credible evidence to suggest that father would have actually changed any part of his lifestyle to provide this child with stable life of any sort. There was nothing there. And I don't think it's fair to the child to sit and wait and hope that maybe in 18 months, maybe this father's other open charges would not result in an additional 2 years. Maybe he's not waiting another 4 years for potentially some stability when he has this home with his sister, with this woman who he calls mom, who is providing him stability and is allowing him to thrive.
Child just turned 6?
He turns 6 next week.
Next week, okay.
Yep.
And is he in the same foster placement?
He is,
With the sister still there.
with his sister, yes.
And to ask Judge Shin's question, that case is finished?
Yes, it is.
Okay, thank you.
If there are no further questions, I'd rest on my brief and ask that this court affirm the judgment.
Thank you very much. That case is submitted. The third case today is 2024 P963, Shannon versus Kim. After that case, we'll take our mid-morning break. And I think we'll hear first from Attorney Waldron.
Good morning, Your Honors. May it please the Court. John Waldron on behalf of the defendants. Your Honors, this case is about Chapter 231, Section 60B, the Medical Malpractice Tribunal statute and the framework for that statute. And the language of 231-60B is clear. It calls for a dismissal of a matter if a bond is not posted within the required 30 days after finding in favor of a defendant. And this is an issue that's been looked at by the courts, by the appeals court and the SJC, and it's been consistently determined that the statute mandates dismissal. And I've referenced this case law in my brief.
So what do we do with the Goldstein case? First, let me just break that down into pieces. What do you think the Goldstein case holds?
I think the Goldstein case is a narrow decision where they allowed a bond to be posted on day 31, where there was a determination that the attorney's understanding of the Rule 6 time requirements allowed him 3 additional days. I think there was some misinterpretation between that rule and another rule, and there was an understanding, a mistaken understanding, but a reasonable understanding that there was some additional time to file the bond, and the bond came in on day 31. That's the only case that we have cited here.
And that was based, though, on an excusable neglect, right?
It was, yes.
Right, so you're making a factual distinction, but what's the legal distinction why the 30 days can't be extended for excusable neglect? Because I read your brief to be saying the judge has no authority to extend the 30 days, but in Goldstein, plainly, the SJC did say you can extend the 30 days.
I think the Goldstein case, again, is a narrow holding that extends it 1 extra day. which is
But
quite
they,
different.
I'm sorry, go finish your answer. I'm sorry.
Which is quite different from the circumstances that are in front of us today. Otherwise, the case law cited in plaintiff's brief to support the concept of excusable neglect deals with rules of procedure. Rule 4, time periods for service of a complaint. Largely, they deal with Rule 4 cases. There's one case, the only case that addresses the time periods required under a statute is the Goldstein matter, which I acknowledge the court held that there was excusable neglect that warranted an additional day, one additional day to post the bond.
And then they drop a footnote that says basically the policy might carry over to other statutes, right? The general policy, it's not how you want to decide cases, I think is the essence of what they're saying.
And I understand that, and I think importantly, all this line of cases looks at not only the language, I think the language has been clear and been ruled upon. They determined that the meaning of the statute and the use of the word shall was meant to be used in the imperative sense to dismiss, that a case shall be dismissed.
Hypothetically, this isn't it, but hypothetically, let's say the bond wasn't posted because the person became deathly ill and incapacitated for a period of time, and then, it's a couple weeks out and they've recovered and they say, oh, well, I didn't have the ability to do that. Why, my case is over now? How do we respond to that? And the judge sitting there doesn't have any discretion whatsoever to say, you know what, this is not what that statute was meant to say and to do in this situation.
I would know if there was an impossibility to post the bond, then I would have to agree that a court may have discretion to do so.
And then how does that jibe with your argument that shall means shall? In 23160B, shall be dismissed means shall be dismissed, and that's the end of the story.
Well, the courts have looked at it as a strict requirement, and they've looked at the underlying reasons for the statute and the framework of the statute. The statute serves public policy concerns. It was enacted in order to address concerns about healthcare-related costs and insurance costs, and the courts reference those, and it underscores the court's interpretation and application of that statute. Understanding that there is a case and there is some precedent for the concept of excusable neglect to perhaps be applied to the statute, but I would submit that it would be applied in a very narrow manner, which is consistent with the strict application of this statute.
So why doesn't this, if we do that, why doesn't this situation fall under that, into that category of cases where the judge should have discretion to excuse the neglect? What about this case sets it outside those parameters?
Our instant matter here?
Yeah.
Well, I think we have to look at the timeline. I think that's important. So the tribunal decision was on November 14th, and it was issued the same day as the hearing, went out to all the parties on on November 30th, 14 days or 16 days after the tribunal decision, there was an emergency motion to stay the bond for purposes of filing interlocutory appeal, which I know is a side note, but I submit is improper under the McMahon case, which I've cited in my brief. And then that was allowed on December 4th. And then for health reasons, the deadline was not recorded accurately, and then that was discovered on December 20th. And on December 20th, which was past the 30 days from the hearing and past the 30 days to file the interlocutory appeal, there was nothing done. There was no action taken with the court. There was no bond filed. There was no motion filed. There was an email sent to lead counsel from my office, generally asking to speak about the case briefly, with no substance about any sort of plan or any sort of proposal relative to the case. That was responded to and acknowledged by counsel from my office with a cell phone number to be contacted. And that was 22 days, or about 3 weeks before the motion to dismiss was filed. And there was no further action taken in this case during that time period. There was a separate identical lawsuit filed in Bristol County Superior Court, presumably because of concerns about the bond requirement, but there was nothing filed in this particular matter. I understand that there was a personal matter involving The other attorney who was representing the plaintiff, separate from the attorney who had the health issue in December, that, according to the brief, lasted a week, so about from the 21st to the 28th. Again, the motion to dismiss wasn't served, and it was served 9A on January 11th.
So, and I need you to keep your voice up a little bit more.
Apologies.
Is there any dispute that the one counsel for the plaintiff was hospitalized and that the other one had some sort of family emergency?
I don't dispute the honesty of counsel presenting those personal matters to the court.
Okay. What prejudice did the defendant suffer for the filing of the bond in April rather than December, other than we don't want to litigate the lawsuit?
The prejudice is just that, the ongoing burden and cost of this lawsuit. These medical malpractice cases naturally play out over 3 to 4 years. So though that period of months can be argued that there is ultimately no prejudice other than some sort of minor delay in discovery or, proceeding with this matter, scheduling. But here we are in March of 2025, and we're still disputing this matter because there's a statutory right that these healthcare providers have to a tribunal, and as an extension, there's a requirement to post a bond in the event of a finding in favor of a defendant. And those requirements are in place for a reason, to avoid those costs and burdens on these healthcare providers. And really, that's the prejudice here. And prejudice is just one consideration in the analysis that plaintiff references in her brief. Acting in good faith or responding in good faith to address a deadline or to comply with the deadline is another factor here. And I understand that there are personal issues that arose, and I'm not here to dispute the honesty of those matters, but there was some time that's quite frankly unaccounted for by the Superior Court's decision. The Superior Court acknowledged that there was a health issue, acknowledged that another counsel had a personal matter, but there's a lot of time that's unaccounted for where there was opportunity to post the bond and one was not filed.
What is your best case that it was an abuse of discretion for the judge to find excusable neglect? Is there any case that you would like us to read?
Well, if I have to pick one, and I'm trying to decide my best, but
You can give more than one if
sure.
you'd like.
So I think that the McMahon case, McMahon v. Glicksman, to start, is an SJC case, 379 Mass 60. I think that case holds that you can't file an interlocutory appeal and also preserve your right to post the bond. You can't have it both ways. It's got to be one or the other. If a plaintiff chooses the path of an interlocutory appeal, you can't do so with the expectation that, well, if this doesn't work out, and just go back and post the bond. It's got to be one or the other. And then the Polanco v. Sander and the Brody cases, they talk about the statutory framework and the public policies that underscore the framework. And I think that's important here because we're looking at, with an extension of time for a statute, what the legislative intent was, as opposed to many of the cases that are referenced in the brief where we're talking about time periods imposed by rules of procedure where you don't have that necessary legislative intent analysis. Finally, this case is brought by the doctrine of present execution. I believe that this case falls right in line with that type of scenario that the doctrine's meant to address, where there are protections and policies that are meant to be implemented by this statute, and waiting until a final resolution would really wipe out those statutes. And if we have to wait till a final judgment in order to file an appeal, those years of costs and those burdens of litigation would be lost. So I submit that this case falls right in line with the cases under the doctrine of present execution. If no further questions, I will rest.
Thank you very much.
Thank you, Your Honors.
Morning, Your Honors. May it please the court. I think this is a textbook case of excusable neglect. The four-pronged test of prejudice, length of delay, reason for delay, moving party, adding in good faith have all been met. The length of delay here has been liberally applied through multiple case laws and extended to Rule 6B2 for the ability of excusable neglect. I would argue that there has been no prejudice placed on the appellee in this point of view, but there would prejudice be highly placed on the appellant, and would be highly placed on the appellee for dismissing this case. The main reason for 6B2 is for this exact textbook reason. The initial bond posting was going to be appealed for an interlocutory appeal, which was approved by the trial court.
Well, what about his position that you had to choose either an interlocutory appeal or post the bond?
I understand there's a citing of the Manma case, and that's not really before the court. I'm happy to file something further on it, but that has been allowed many, many times in Superior Court, a stay of the posting of the bond until the appellate court has made that decision. So I understand there's one case law against it, but there's many, many other cases that this has been allowed, and I personally filed many of those cases, and it's always been allowed. So I'm happy to further brief that, but I didn't prepare that in terms of case law to support it because it wasn't really the topic of excusable neglect, but I apologize for that. The prejudice beyond it, again, had the bond been posted and not the interlocutory appeal been pursued, the $6,000 bond would have been there and the case would have gone forward.
So this was more in his briefing than in his argument, which was basically, but as soon as you discovered the error in terms of calendaring, you didn't immediately post the bond, that there was some continued delay and lack of diligence and continuing to try to get out of posting the bond. So what do you say to that?
I would argue there's no trying to get out of posting the bond. There was an immediate call and email placed to defense counsel. They were not reached. I'm Attorney Catherine Buchenheiser, by the way.
I'm sorry.
I'm Attorney Cat.
Whenever that door opens and closes, I cannot hear what you're saying. I cannot. I wish we would just prop the thing open.
Sorry, Your Honor. What I was saying is I'm Attorney Catherine Buchenheiser, so I immediately called defense counsel on that Thursday night, didn't reach him, actually tried him on his cell phone. He emailed back the next morning. I emailed him saying, I want to talk about this issue. And then unfortunately, I had a serious family emergency that took me out. It was also over the holiday period. When we got back, there was telephone calls back and forth that they were going to be filing this motion. I said, okay, let's file the motion and we'll move on from there. There was no attempt to avert to pay the bond. The bond was always going to be paid if the case had gone up on interlocutory appeal and was in fact denied. That was never an issue. And when the Judge Cowan heard and granted the excusable neglect, she also allowed for time to apply for indigency. And that is often applied for in bond in terms of the $6,000 appeal if the estate is indigent of being able to post that $6,000 bond. It was denied for several reasons, and then the bond was immediately posted before the time allowed by the judge at that point in time. And again,
Can I just circle back? I know you say you didn't brief it, and understandably, maybe because of my question, when the question about whether you have to pick interlocutory appeal or post the bond, and you say there are plenty of cases that say you can do one while doing the other, but in this sort of a situation, legally, there's no right to interlocutory appeal, correct? On a tribunal decision. Am I misreading that?
I don't believe there's no legal right. It's been done several times, and I think
Okay.
it's the difference of when it goes to a single justice for a three-tier justice. I'm not at the point where I can argue that intelligently and cite different portions to that. But I would go to the propose that the judge on November 30th granted that liberally and stayed the posting of the bond until the interlocutory appeal had been decided. And arguably, when that was stayed on November 30th, it would not have been decided in less than 30 days. So that time of the 14th of December wouldn't even have been the date had had the interlocutory appeal been filed. And unfortunately, Attorney McAllister from my office was hospitalized in the interim of that. And he was an individual who argued the initial tribunal, who filed the motion for the extended stay of time, and then was writing the interlocutory appeal at the time. So when he was still in the hospital and we understood the calendar was scheduled for the 22nd, I picked it up to try to finish the interlocutory appeal and then realized, oh shoot, there's a calendaring error. And we immediately went to address it. In terms of the bond, yes, there was an additional filing that we did because the statute of limitations had not yet passed, and that was going to be in August of the following year. So that was just sort of like a backup in case whatever were to happen here, but there was no intent to avoid posting a bond. That was initially from the beginning, had it been denied an interlocutory appeal, bond would have been posted. So
what is your best case on excusable neglect?
Well, I first would say that the standard review is abuse of discretion, but for the excusable neglect, the Mata versus Schmidt, Commissioner of Revenue versus Kerrigan, it's all for an unreasonable excuse. And if there has been no prejudice and no tactical delay by plaintiff with good effort, that the excusable neglect is liberally applied, and it's an elastic concept.
So the argument that the prejudice here is, well, we have to actually go try our case, and you've not, I take it you're not...
I would argue that that was inevitably going to be the situation had the appellate court denied the bond or had denied the overturn or had the bond had been posted in time. That was, the case was always going to go forward.
Okay.
And again, the statute of limitations hadn't yet passed. So at that point in time, there was still time to, should it be needed, refiled.
Do you agree that this appeal is properly before us under the doctrine of present execution?
That's a hard question. I don't believe that. Do I think it's properly before you? The public policy and doctrine of execution goes back to this burden of the med mal, them having to try the case. I think that was always going to be there. And to bring it at the end of the case versus now, I don't see how that is applicable to this instant.
I guess someone might say, well, again, and I don't want to go on anecdote, but I happen to know they just finished a case next door that was about 8 or 10 years old, I think. So that, especially in these cases, it appears that the tracking has gone way off track, and so that the point is you have doctors who kind of have their lives, if not actually, but emotionally on hold for a decade.
Yeah. Unfortunately, especially with COVID, I think that all firms...
That's not wrong, right? That's kind of, if you do this
No,
work, they're pretty backed up on these cases.
It's been extremely backed up, especially with COVID. I mean, we're booking trials out when we file them this year into 28, 29, and I mean, it's an ordinarily
That in cases that
time.
likely between the tribunal and where you are when you're booking the case, we're already 3 or 4 years anyway old?
Correct. The 60B statute says within 15 days, the tribunal is supposed to be heard. Even before COVID in my practice, I would have tribunals after the pretrial memorandum and the pretrial conference was submitted. So I don't, not to criticize the justice system, but the tribunal purposes has not been followed through the 60B 15-day rule as far as I've been practicing for 17 years. They certainly try. But it's just, I think, the volume or the court system or all the cases involved, I can't really speak to that. But I don't think this case falls anything different. We have a trial date in this matter, which one of the things that most plaintiffs' counsel has been doing is when you file a case, you get a trial date versus before COVID waiting till the pretrial conference, so then you have a certain tracking order that's going to be followed more rigidly than one where you're waiting to the pretrial conference to pick a trial date. This case is no exception to that. It followed in that tracking line. And again, I would just say that the prejudice would solely lie on the plaintiff in this case if it were to be kicked out versus having the defendants have to continue to defend the case. And with that, I would rest on my papers if there's no further questions.
Thank you very much. We're going to take our mid-morning break. The afternoon, or the second session, has 3 cases argued by the same attorneys, and so we'll talk about that scheduling when we return.
session, please be seated.
Again, good morning. We have 3 cases that all involve the Barnstable Conservation Commission. I'm going to put all 3 case numbers on the record right now, 2024 P673, 2024 P674, and 2024 P675. We are going to have 15 minutes per side for each case on the clock, but to reiterate what I think you've already been told, there's no need to repeat arguments, and we are quite familiar with your materials. So I would encourage you to get to the heart of the matter. So if you don't use all 15 minutes, that's fine. And if you need it, that's fine too. So with that, we'll begin with case 2024 P673, JMS Holdings LLC versus Barnstable Conservation Commission.
Good morning. May it please the court, members of the panel. My name is Brian WAHL. I'm an attorney. I have an office in Sandwich. With me together is my associate, Clodagh Troy, who worked on all 3 of these briefs. Your Honor, I know that you said that you're familiar with it and being cognizant of that. I won't get into the details, but since each one of these involves a dock and each dock is a little different, I just want to take 1 minute and just orientate us to which case we're talking about. So in the case of JMS, the entity has a existing pier that was permitted in 2003. It's 138 feet long. Of that 138 feet, the first section, which is 58 feet long, is permanent, and it's supported on what's called monopiles, which is a single pile driven into the substrate, and then it has kind of a Y at the top that holds the walkway above it. The second section is a seasonal section, which is supported by 4-inch by 4-inch posts that comes in and out in the spring and in the fall. That leads to a 3 by 14-foot ramp, which extends down to a 4-foot by 25-foot float. And the float is also seasonal, pursuant to condition number 9 in the permit that authorizes that float comes in and out of the water every season.
So the float is not in touching section 1, is that right?
The way that if you were to physically walk on the pier, Your Honor, you would walk on this elevated walkway until you got to the end of the walkway, where then there'd be 2 piles that are permanent there in the water, where the ramp is connected that extends down. And the reason there's a ramp is because the water is tidal, so it goes up and down a little bit, and so the ramp has wheels on the end so that it goes up and down like that, so that you can always access the float. But the ramp and the float come out at the end of the season and go in the spring. The piles that anchor the float and that support the top of the ramp remain permanently in the water. So the proposal is to replace the first section of monopiles with pairs of piles, because that's kind of the standard way that these are constructed, and it's more sturdy, and then to make permanent the seasonal section that extends out to that ramp and float. And critical to one of our primary arguments is that there was no work whatsoever proposed on the piles out at the terminal end of the pier, or on the ramp, or on the float. And that segues to my first argument. The Conservation Commission is an administrative agency, a regulatory agency. It was created by legislation at the municipal level. The town of Barnstable is a town, but it has the city form of government. So the town council, as in CIL, enacted the Wetlands Protection Ordinance that created the Conservation Commission and gave it authority to regulate certain wetlands resources. And it also authorized it to grant permits and also to deny permits. And in so doing, the ordinance also specifically empowers the Conservation Commission to regulate work or activities in certain resource areas. And specifically in the ordinance, it says, "No person shall remove, fill, dredge, or alter a wetland resource except as permitted by the Commission." And then there's a definition of alter in the bylaw that says alter is to change the condition of areas within the jurisdiction. So in this particular instance, the project is to replace the elevated walkway section No work whatsoever was proposed on the ramp or the float. And our contention is that since no work was proposed on that part of the dock, the commission did not have any jurisdiction or authority to condition that dock, the float. The 2003 permit did condition it. It said that boats must be berthed at the float, and it also said that there must be 12 inches of water between the bottom of the boat and the bottom of the ocean. And
So I want to pause you because I understood you when you were saying sections 1, section 2, and section 3. But I'm not clear where the work is being proposed. The work is being done on sections 1 and 2 or just 1? You lost me then.
1 and 2. So again, Your Honor, if I may, the first section is a permanent section with monopiles.
Right, and you want to change it to 2.
Twos. And then the second section of the walkway is an elevated walkway that goes in and out each year, and it's on 4x4 posts. And they want to make it uniform from the shore all the way to the ramp. They want it to be the same, pairs of piles with an elevated walkway.
Okay. And then would the ramp become permanent, or the ramp would still be temporary?
The
seasonal?
ramp will be exactly as it is under the current permit. It will be in the same place. It will be taken in and out at the beginning of each season and at the end of each season. It will be exactly the same. And what I was also...
Is there a picture of the float in the record?
My associate will look for the record. There's certainly plans that show the float, and there are photos. There are photos too that show.
If she finds something, she can let you know. I don't want to slow you
Certainly, Your
down.
Honor. Yeah, we'll find it. I'm sorry.
And I also just wanted to understand, so if the current ruling stands, your client can continue to do exactly what they're doing?
That's exactly right. If the case has not prevailed here, they can simply not exercise this permit, which again approved the proposed project. But what it also did was it added a condition to use of the float.
Which would mean that you couldn't dock a boat at the float?
Exactly, Your Honor. And not only not dock a motorized boat, because the new regulation at issue says that when you are in an area significant of shellfish, which we can see that, there has to be 30 inches of depth between the bottom of the boat and the bottom of the ocean. And here there's about 22.8. There's about 2 feet of water where the boat is currently docked.
So would it mean they couldn't dock just a motorized boat, or would it mean they couldn't dock any kind of boat?
That's one of our arguments. I think the commission, to be fair, probably meant no motorized boat, but that's not what they said. They said no boat whatsoever. So if this permit were to be recorded at the registry and exercised, and they built this new elevated walkway, they would not be able to use the float for any boat under the permit, as it currently reads. So just to make sure I'm clear here, Your Honor, too, so the part that is being worked upon is from the shore to the terminal end where the ramp begins. And because there's no work whatsoever proposed on the ramp or the float, our argument is that when a project is submitted to the commission's authority is circumscribed by the project itself. They don't have the right to condition anything on the property, just what's being proposed. They can condition the work. And there was no work proposed on the float or dock, no change proposed, and hence the fact that they conditioned the use of the dock exceeded their authority.
So I don't know if this is an appropriate analogy, but I had been thinking about this as a porch and a sidewalk, and I thought you were proposing work on the sidewalk, but it seems like you're really proposing work on the porch and they want to regulate the sidewalk.
That's one way to say it. Another way is the Barrett case that I've submitted, and I can see that that's not a case of record, it's not a reported case, but in the Barrett case...
That's the backyard, front yard?
Yes, so the particular property owner in that issue, at issue, had a house and they had a front yard, and in the backyard there was a saltwater canal, which was obviously under the jurisdiction of the Falmouth Conservation Commission. And what the Barretts wanted to do was replace their septic system and do some reconfiguration of their driveway and some landscaping. The commission approved that project, but then said, oh, and by the way, in the backyard by the canal, we want you to plant a vegetated buffer strip. And in that particular instance, the court said there was no work proposed back there. You didn't have authority to just put conditions, and I could extrapolate
Right, but this seems a little bit different, because, and I'm not saying it's dispositive, but here the ramp is attaching to the work you are planning to do, and that's why it seemed to me like that I don't know how this case is going to come out, but it seems like I could see that if the porch was staying the same and you just wanted to do the sidewalk, they can't get to the porch, but when it's the other way around, I'm not quite as sure.
Well, our contention is that the work is limited to the point from the shore until you get to where the ramp begins. No work is done on the ramp or the float, and therefore our contention is that was beyond the commission's authority.
But the elevated walkway is over an area that at some times has water underneath it?
The elevated walkway?
Yeah.
Almost the entire walkway is over the water. Yeah, absolutely.
So their argument, I suppose, is that anything in and around and over the water, that's our purview.
Your Honor, that's exactly what the town's argument is. And so if you read the opposition brief, the town's argument says, well, wait a minute, the structure is in the resource area. We have jurisdiction over the resource area, and therefore we can regulate it. But we think that's a wrong argument, and here's why. You can extrapolate that extremely. So for example, my client's house is in what's called buffer zone, and it's also in what's called land subject to coastal storm flowage, which is the floodplain, and those are resource areas. And so I posit to you, Your Honor, does a project that proposes to rebuild a walkway to a pier, can they then say, well, we want you to do X, Y, and Z to your house, we want you to plant your lawn full of plants? No, I don't think that's how it works. Is you propose a project that wants to do certain things in a certain way, and the Commission has the authority to regulate that project, not all of your property. And I think that's a really key point, because again, this case will be hopefully a case of record, and all the conservation commissions in the Commonwealth, as well as other agencies like the Department of Registry of Motor Vehicles, they're going to look at, say, because this is what I think this case stands for, is when there's an agency that's empowered by enabling legislation, all its actions have to be authorized by that legislation. It can't just exceed that authority. And I think that's one of the issues that's presented by this particular case.
So, but if you're proposing work on Section 2 with the walkway, can they say, well, you could do what you want for Section 2, but you can't connect anything to it after that? Like, in other words, you just can't have the ramp.
I don't see how they could, Your Honor, but I'm going to answer that question a slightly different way. You have to, I would suggest, focus on the fact that the float is there. It's permitted by a permit. It's been used for 20 years. There's a shellfish study from 1997 in the record before there was a dock that indicates what the conditions were there then. And then as part of this project, a new shellfish survey had to be submitted, which essentially shows the same conditions, including the bottom condition and the shellfish condition. So that float has been out there and has not had any adverse effects on the environment, which kind of segues to another argument I have further on, which is that it was an abuse of discretion for the Commission to impose this condition when there was no work proposed out there and there's hard evidence of no adverse effect on the environment.
Isn't that part of it, though, just really a weighing of evidence as opposed to whether there's substantial evidence, I suppose?
Well, I think my point, Your Honor, would be that the evidence is very clear in the record. It's undisputed, and their ultimate goal here.
That it hasn't, to this point, impacted the shellfish at all. And you're saying that really forms the basis for, or to then say, well, if you change something that really isn't changing the dynamic here, it's going to have an impact. It's utter speculation. Is that, am I paraphrasing what you're saying?
I agree with Your Honor. Yes, that's a correct summation of what we're trying to say. Because there were 3 requests for waivers here too, and they granted 2, one as to length and one as to location, but they denied the request for waiver with regard to the depth. And our argument on that is that was an abuse of discretion given the evidence that was in the record. But I only have another minute and a half. I skipped over. My middle argument is that these regulations were adopted in 2004 after the existing pier was constructed. And in the regulations, it provides protection for what I call vested rights or existing piers. And it says that when an application is filed, so any alteration whatsoever to a dock requires a filing with the Conservation Commission. But there's a provision of the regulations that say only when there's a substantial expansion of an existing dock do the new requirements kick in. And our argument, and it's all in the brief, and I'm running out of time, is that there is no substantial expansion here. The walkway is the same width, same length, same height. It's just replacing what's already there.
Right, but they say expansion can apply to time.
Right. And so my response to that, Your Honor, is I have a multifold response to that, and I'll be very, very brief. So first of all, the regulations, the exact language says a substantial change to an existing dock. And a dock is defined in the regulations, and the dock is defined as the structure and the pilings. It makes no mention of time. There's another section that talks about seasonal. So our argument is they could have mentioned that, but they didn't. So therefore, the reference of substantial change is to the structure, not the use. And lastly, Your Honor, I'll just simply say, as I mentioned earlier, the pilings that support the ramp and the float are there permanently. And so all we're doing is connecting the permanent section to the permanent piles that are already existing. Nothing is expanding.
So if we accept your interpretation of substantial expansion, it would mean that you weren't required to even seek the first two waivers, right?
That's correct, absolutely.
So you could just do whatever you want to this pier as long as you don't change the overall footprint.
Not whatever, Your Honor, because still the bylaw itself says that the commission is empowered to, let me back up, the bylaw identifies what are resource areas, identifies what interests are protected in those resource areas, and the bylaw, not the regulations, but the bylaw, I call it bylaw, it's an ordinance. The ordinance says that the commission is empowered to deny a permit if the project will have significant unacceptable impacts. And so just because you have a pre-existing dock does not give you carte blanche, but it does protect you from the new regulations. And what happened here was the float has 22.8 inches of water. The commission saw this as an opportunity to say, oh, you want to do work on your dock? By the way, you have to comply with this new regulation. And by the way, if you do that, you can't have a boat. And our simple argument is after 20 years of boat usage with no evidence of adverse effect, that was an abuse of discretion and beyond their authority. Thank you very much.
We'll hear from the commission.
Good morning, Your Honors. May it please the Court. I am Kate Connolly, Assistant Town Attorney in the Legal Department of the Town of Barnstable. We are here before you, as you know, on 3 separate cases that have been consolidated for oral argument because they involve not only the same appellee, but also the same ordinances. The Chapter 237 of the Barnstable Code, which is the Wetlands Protection Ordinance, which has certain provisions, including the value of shellfish, that is more stringent than the State Wetlands Protection Act, Chapter 131, Section 40, and also contains a more stringent burden of proof.
So I wanted to start with a couple of points that he just covered. Sure. Do you agree the special condition effectively precludes use of a motorized boat at the existing float if the pier becomes permanent, or any boat?
Any boat, Your Honor. And
any boat.
We feel that the commission was very reasonable, reviews projects on a case-by-case basis, and that is one of the provisions in the the private docks and pier ordinance, Chapter 703. They granted 2 of the 3 requested waivers, which we feel shows that they are being reasonable in their application of the local ordinance, but they denied the waiver which would allow for a 12-inch depth under the propeller, and therefore imposing a condition, pardon me while I read from my notes because these cases are similar enough and different enough that I'm relying a little bit more than I normally would on my notes. But because there's a waiver from the requirement of a minimum 30-inch clearance from the bottom of a boat to the marine substrate at mean low watermark would cause adverse impacts to the resource area. And in denying that waiver, which is in the ordinance for a reason to protect the wetlands resource area, due to the denial of the depth waiver, the Commission also imposed that condition which precludes use of a boat. It says no boat shall be used or berthed at the approved pier such that at any time less than 30 inches of water resides between the bottom of the boat or the propeller in the full downward position, whichever is lower, and the top of the substrate. And the reason is to protect the
I don't
area
understand.
underneath.
The regulation itself applies only to motorized boats.
Oh, no, I'm sorry. It applies to any
The
boat or
regulation
object.
applies to motorized vessels.
Right, we're looking at 703-4M?
M.
M, right?
The following depth requirements must be met for motorized vessels.
Right, and there's another provision says it can't interfere with recreation. They may have meant motorized boats, but
Well, that's important, isn't it? I mean, I just thought that was an error, to be honest, in the special condition. I thought that no boats was an error, that it should have said no motorized boats.
They may have meant no motorized boat, but I think the important point here for the commission is the argument about the substantial change versus substantial expansion. And
Can
the
you just hold
commission
that
did.
up? When you say they may have meant motorized boats, who is the "they" you're referring to?
I'm sorry?
Whom are you referring to when you say they may have meant
Oh, I'm
motorized
sorry,
boats?
the Conservation Commission, when it
Right.
issued its findings.
Say may, okay. All right, okay.
So again, the substantial change versus substantial expansion, the commission felt that the temporal change is just as important as if the structure is changed. So the
Right,
use
but,
of the property.
I know it's just a figure of speech, but whenever my law clerks say feel, I almost lose my mind. So we don't deal in feelings here. The issue is he's arguing substantial change modifies what a dock is, and that there's another section that refers to temporal, seasonal. So why is he wrong about that?
Because the commission didn't put language either way, that it referred just to the structure or to the use. And it was reasonable for the commission. I can quote from the transcript, one of the commission members said, "The legal definition of substantial expansion is having importance or significance." So I say to myself, in replacing a 4x8 seasonal
So
that's
can I
only
just-
used
just
4
before you
months.
Just before you finish, because I read that, and it seems to me that that definition is for substantial. What about the expansion part?
Well, they're expanding the time from 4 months a year to 12 months a year. And the reference my brother made earlier to the fact that there haven't been environmental adverse impacts for 20 years, the commission's decision was based on testimony by their shellfish constable, as well as the researcher, the shellfish biologist, and many studies that they looked at. They concluded that the lack of changes over 20 years was based on the fact that it was a seasonal pier.
As I understand it, the part that's in the water is not becoming permanent, it's just the part that's hovering over the water, right? Am I wrong?
They're only changing one portion of, I guess, three
But not
parts.
the part that touches water at any time ever. Is that wrong?
I believe that all parts of the project are in the water, so the resource areas.
Well, we need to be clear on that, whether you, and I would invite a post-argument letter, because what I understood him to say was that what's in the water is not changing, and so we're talking about, I guess, shade or coverage of water, but not what, like, that, if that's disputed, we need to know that.
Because he says elevated walkway. Elevated to me means above, over.
No, correct, and I believe that part is not in the water. But the commission's view is it's one project. The applicant made much of the fact that there had been.
Right, but just to answer my question.
Sorry.
The parts that are actually in the water, there's no dispute, those are not changing. They'll be coming out.
That's
in
correct.
the winter and going back in the spring.
Yes, we agree on those
So
facts.
to the extent that there's an impact on the shellfish based on something being in the water, it doesn't apply to the elevated walkway, it would seem, right? On that part of it.
That's
I know you have a
correct.
different argument. Okay.
But again, the commission felt that substantial expansion, you just look at the ordinary meaning of words, and changing the structure could be one way to interpret substantial expansion. Changing the use in terms of the amount of time, which going from 4 months seasonal to 12 months permanent.
Even if we were to accept that reading, how is there a change in use of the float?
There's no change.
Project doesn't, right, the project doesn't propose any change in the use of the float.
Correct. But it's because it's part of the same project, the commission applied the regulations under the Chapter 703.
But it's a separate component that's not going to change at all. I mean, explain to me in very simple terms how changing the other parts of the structure from seasonal to permanent is going to affect the use of the float in any way, or is it not?
It's just the fact that it's all one project, the parts are...
You can just consider it one big structure. So you can only change this if you comply with this condition on something that's not affected by the work.
The commission's conclusion, after listening to all of the testimony, was that the part that's being changed is going to have a substantial impact and possibly cause, or would cause...
But that was still approved. I mean, the permit was approved.
Correct, with denial of the depth waiver.
Okay.
They granted 2 of the waivers that were requested.
So if I understand your argument, let's say, and I just don't know because I'm not looking at a picture and the words are not drawing enough of an image in my head, but if the very closest part of this structure to the house is in the ground, okay, and they want to put a flower next to it or a plant next to it in the ground, or put a new post in the ground, you're saying that that decision would impact and would enable the commission to say, well, you know, 100 feet away or 200 feet away where it's part of, although it's touching it, part of the extended touching is in water, we have jurisdiction over you doing something on your lawn? Is that the gist of it?
No, and
it seems to me like the front yard, backyard case.
No, Your Honor, and the commission here didn't, and I want to distinguish the Falmouth case because that was very different in that that commission tried to regulate property on the other side of the residential structure from where the proposal was, and that was completely unreasonable for them to do that because that's not what the project was. But in this case, the application was for a project that's all in the resource area. Hence, the commission regulated the entire project. And distinguishing also the Bergeron case, which my brother mentioned in his brief, and that's a previous Barnstable case from back in 2009, before my time. But there were several distinguishing factors with respect to that case. One is that the commission made a statement on the record that they didn't want the area to become, I believe it was the Centerville River, to become a parking lot for boats, and that nobody, at that point, the ordinance had been in effect for 5 years, nobody had gotten any waivers or variances at that time, and the court viewed that as a blanket prohibition against piers and felt that that was showing an ad hoc agenda. And the commission's been very careful since then to review each application on a case-by-case basis. The other difference in that case, the Bergeron case, which my brother cites, is that it's a zero shellfish area, so it didn't provide shellfish habitat or the concerns that the commission in this case had, because it was also a dead-end area, so there's little possibility for any kind of impacts to wetlands. And also, in that case, they were seeking a length variance in order to meet the depth requirement, and the commission considers the depth requirement of the ordinance to be very important because of the fact that scouring can occur if something is too close to the bottom, too close to the land.
Have you finished that answer? Because before you transition to a different point, I want to ask a different question. If you haven't finished, definitely finish the answer.
Yes, Your Honor. Okay. I'm finished.
All right. So his big argument is that we're supposed to have these rules and regulations so that people understand what they can and cannot do, and that there's some predictability, that it's not arbitrary. And he argues that whatever standard the commission is applying isn't clear. Or it may be that there's no adverse impact. So I'm asking you, what standard are they applying? And that they're going to apply to everyone?
They're applying the preamble, which has certain presumptions.
They're applying the...
You said it again, I'm sorry.
Sorry, the preamble, which is section 1 of the document. It's 703-1, and there are multiple sections that they applied. The appellant does argue that there's no test in the regulations, but the commission's argument is that they use the ordinary meaning of words to determine what's an adverse impact. And the town wetlands ordinance does contain a statement of jurisdiction. It says that they have the authority to determine that an activity occurring beyond the limit of jurisdiction noted above is having or has had a significant effect on wetlands values or a wetland resource area. There are also multiple sections of the dock and pier ordinance that the commission, in addition to the presumptions in the preamble, there's then a section of definitions. Section 3 is filing protocols, and then there are numerous regulations throughout sections 4, 5, and 6. So they review the entire thing, the entire private docks and piers ordinance, but also the wetlands ordinance, and they all have to be read together in accordance with the ordinary course. Many applicants have come before the commission. Some have been granted, some have been denied, and in one of the other hearings that is before the court today, the applicant's consultant made a comment that that particular applicant was being treated unfairly. But the record is pretty clear that when the commission grants the docks or piers, it's typically because it's a different environmental situation, it's not in a high shellfish value area, and members of the commission at the hearing at which the applicant's consultant made that comment were able to distinguish every one that had been granted. But I think it's also important to note that when the applicant is talking about it being unfair or an ad hoc agenda, the commission is careful to follow the provision that says they must review every case on a case-by-case basis, and the fact that they've granted some pier approvals and denied others shows that they're being fair in doing that. And unless there are further questions.
Well, I guess that's the question, though, because it could show that, or it could just show some people are better connected. And that's if you can't predict from looking at the written rules, then how do we know that this is a fair process?
Because the commission reviews the regulations, discusses the project, they do a site inspection, and they relied and mentioned multiple times in each of these hearings that they do rely on the expertise of the town shellfish biologist, because she's there to advise them. And she provided testimony about her shellfish studies and why this is an important shellfish area, and specifically why turbidity and scouring from putting a permanent pier in would have cumulative negative impacts on the wetlands resource area.
So turbidity and scouring, that, as I understand it, is what happens if it's too close to the bottom and the propeller in a motorboat is shaking up the bottom of the
Correct.
ocean there, right? Okay. So I'm having, again, a hard time. So I get it as it relates, we're not there yet, I get it as it relates to permanent versus seasonal floats that are touching water and where you have boats up there. But if that's not changing at all, how does, I'm missing the literal connection other than, I'm missing anything other than the literal connection between the up top immovable part and the parts that are down touching the water.
It's the depth waiver going from 30 inches to 12 inches that is of concern to the commission. And also
so if we're being honest, this is sort of like they see an angle and they got a gap to shoot to say, okay, never mind on that okay we gave you before we changed up the height or the depth restriction. Is that fair? I mean, that's what we're really looking at here, seems to me. I'm not saying it's right or wrong, whether it can be legally defended. I'm just saying that.
I think they were fair in that the pier that was there before was before they adopted the dock and pier ordinance in 2004, and that's because there was a plethora of applications, and they realized that they needed to focus not just this neighborhood, although there's a lot of docks and piers being requested in this particular neighborhood, but they did studies before they adopted the dock and pier ordinance. And the one that's there before was permitted through a DEP. There's a lot of talk in the brief about this, and appellant's brief, but our position is that it's not, it may be grandfathered and it can stay there, but if they're going to make any changes to it, it's a brand-new application that is now subject to the new ordinance.
Right, but so I'm not sure we've gotten an answer to what key point of his, which is that the commission's authority is circumscribed by the scope of the work, and the scope of the work did not include the ramp and the float. What do you say to that? Why is he wrong about that? Because it has some appeal.
Because the commission reviewed it as one project, and it's all.
That's just, that's Ipsy Dixit. right? That's just, we said so, it's one project. And he's like, no, it's not. You're not doing anything on Section 3, it's just getting out to Section 3. So what gives the commission the ability to say, you could have said you're not getting to Section 3, but you said, okay, he can get to Section 3. So since there's no work being done on Section 3, why is that in the scope of the work? Because there's no work there.
Again, I come back to, because they're changing seasonal use 4 months out of the year to permanent.
Not for the ramp and the float. They're not changing those, right? You
Correct.
agree? They're not, okay.
But they're using the whole thing. They would be if they didn't have that one waiver provision. They're using the whole thing for 12 months.
Oh,
rather
hang
than
on a sec, but when you say they're using the whole thing, what are you saying, they're going to walk off the plank, essentially? They're taking the ramp and the float off, and they're going to have a permanent walkway. They're just going to walk out and jump to their boat that's not attached to anything? I don't get that. I don't mean to be facetious, but you get what I'm saying?
I do, Your Honor.
Yeah, so that's not really affecting the year-round use of that water that might impact the shellfish, it seems to me, on this particular case, right? Because again, when you say it, to Justice Henry's question, this part, which is the above the water that never touches the water walkway, really for the winter season, essentially, I presume they put something across it so people literally don't walk off, right? But it's not attached to anything that's touching water or in any way that accesses water or the muddy stuff that leads up
That's
to it.
correct. But again, the commission viewed this as one project and was concerned about the extension of the temporal use of it.
Okay.
All right, are you good? Okay. All right, well, we'll move on then to the next case, which is 2024 P674 Sean D. Martin versus Barnstable Conservation Commission. And again, just in case anyone's later listening to these arguments, we're hearing 3 cases together, 673, this case 674, and 675.
Thank you, Your Honor. Again, members of the panel, for the record, my name is Brian WAHL, and with my associate Clodagh Troy, we represent the plaintiff and the appellant, Sean Martin, trustee of the 310 North Bay Road Realty Trust. Just once again, because of the physicality of this, I'll very briefly describe the dock in this case. The Martin family has a dock that was permitted in 2002. At the time it was permitted, it extended 100 feet out into the water. Due to some changes in conditions, it now is 94 plus or minus feet out into the water. The distance that I just described includes a walkway, a 3-foot by 14-foot ramp going down to an 8-foot by 16-foot float. The pier at issue is seasonal, so it's supported by 4-inch posts that are taken in at the end of the year and taken out of the water and into the land at the end of the year and put into the water at the beginning of the boating season, which this applies to this case, and I don't mean to say anything further about the last case, but the season is not 4 months, it's more like 6. The boating season begins in or about May and goes into about October.
One question I was confused about on this set of facts is that you say the size of the pier won't change, but I think you're also saying that the piles or the posts are going to would change from 4 inches to 12 inches. Is that right?
That is correct. And so not to, again, crossing over cases, in the last case, because of the monopiles and the 4x4 posts, the new elevated walkway would actually occupy less of the bottom because of the construction. It was 38 feet with the monopiles and the 4x4 posts and about 17 and a half feet with a new elevated walkway. In this instance, because it's all 4
You
by...
say 4, that's what you're describing from the last?
The last case.
Okay, here.
This case, Your Honor, is correct, that the area occupied by the 4-foot posts compared to what would be occupied by the 12...
4-inch posts?
4-inch
You
posts.
said foot, but you mean 4-inch?
Yeah, I'm sorry, I don't really
That's
even remember
okay.
what I said.
Yes.
The 4x4, the 4-inch by 4-inch posts that are there, they're not as sturdy as what are called 12-inch round piles. And so in this particular instance, the length of the pier will be the same. The height will be the same, the width will be the same, the area of bottom occupation will be slightly more with the piles that are in place.
Same number of piles, or there are fewer because they're bigger?
I believe that there are fewer piles. I'd have to check the record on that, but I believe there are going to be 16 piles put in to make this seasonal section permanent. And again, at the end is the ramp and the float, and that comes out seasonally. So what we're talking about is just the walkway section. And I'd like to pick up on what Justice Henry was talking about the last time about rules and predictability. So without going back to basics, again, the town of Barnstable passed a wetlands ordinance, and that has some broad language that says the commission regulates wetland resource areas, and it can grant a permit when the permit would not likely have a significant or cumulative effect upon the wetland values. And the commission is empowered to deny a permit if the proposed project would have unacceptable, significant, or cumulative effects. The commission in 2004, taking that broad authority, and the town council also gave the commission authority to enact regulations. The commission enacted 9 pages of private dock and pier regulations that talk about, first, presumptions that docks can have adverse impacts if they're unregulated. And then there's a section that talks about definitions. And then you get to a section called regulations, or sometimes called performance standards. And these standards are design criteria. So it talks about you can have a maximum length of X. In this case, it depends upon your lot frontage, but in no event longer than 100 feet. It talks about width. It talks about plank spacing. It talks about piles, lighting, storage of the floats in a nice, safe area off-season, et cetera, et cetera.
I don't mean to cut you off here, but do I understand your argument about the preamble, which I presume you're getting to, is that it's so broad that effectively it allows them to pick and choose and to plug in where they like someone will give you this, we'll approve this one, and we won't, and because it's such a broad set of language, or not, is that not what you're saying?
The argument is a little bit more nuanced than that, Your Honor.
Yeah,
What we're saying is that there is a preamble, and the preamble says things like turbidity. Prop dredging can cause turbidity. Turbidity is bad for shellfish, so that can be an impact from a pier. It talks about length. If you extend a pier out into a waterway, you're going to be adversely impacting other recreational boaters who are passing back and forth. But what happens, and this is the key to our argument, so there are all these statements of adverse effects, and then the commission adopted performance standards, and at the end of those performance standards, it says, a dock that complies with all these standards is presumed to minimize all those adverse effects that are referred to in the preamble. And that segues exactly to our argument. In this particular instance, Mr. Martin hired an engineer and a wetlands consultant. The wetlands consultant practices in the town and is familiar with all these regulations and designed an elevated walkway that complies with all of the regulations. And so our argument goes like this. A regulatory agency is created by enabling legislation. It has authority to enact regulations and performance standards. Barnstable did that, and by doing so, they therefore set the rules of the road for people that want to come before them and apply for permits.
All it says it minimizes impacts, but something can minimize impacts and still have significant impacts, right?
It can, Your Honor.
Yes.
And so I have 2 points to make about that. The first is, I think you have to read the regulation in total. And so it does use those precise words, and so it leaves open the possibility that even if you meet the regulations, there could be some adverse effect. But then you go back to the bylaw, and if the commission finds an adverse effect that was not minimized, or it was minimized but still is unacceptable, then they have to follow the language of the bylaw, and they have to make a finding that the proposed pier project would have a significant, unacceptable adverse effect, not just any adverse effect.
Isn't that implicit in the findings that would result in permanent loss of shellfish habitat?
I would beg to differ, Your Honor, for the following reasons. One is, again, the rules of the road are set. So when they said you can have a pier of 100 feet in length, they can extrapolate how much area is going to be occupied on the bottom. They have a regulation that protects shellfish, And the only one is it has to do with depth. So the town has a mapping system where they have values of 0 to 10, and if you're 0 to 5, it's not significant, and if you're 6 to 10, you are significant. And all our cases are in significant shellfish habitat. But the only regulation that they have about that is not about occupying the bottom. They could have had that, but they don't. They have a regulation that says if you are in significant habitat, you have to have 30 inches of depth at the end of your dock in order to have a motorized boat. And in this case, the Martins have a condition on their pier of non-motorized boats only. And that actually segues to a very good point that we're trying to make, Your Honor, is that that's where the arbitrariness comes in. Because if you meet all the criteria, you have a dock that is the right width, the right length, et cetera, how can the commission come along and say, you're occupying too much bottom? That's a standardless standard, because
Can I ask you about the sentence in section 703-5A, the last sentence?
703-5A?
Yep, the last sentence. A project which may otherwise comply with these regulations and guidelines may be denied where its cumulative effect would result in adverse impact upon the protected resource areas.
Yes.
And there's a finding by the commission that this project would have a cumulative effect on the overall water sheet. So why isn't that an adequate basis, an adequate finding?
So I don't think it uses the word significant, unacceptable cumulative effect. It just uses the word cumulative
Well, it says,
effect.
I thought the ordinance itself is significant or cumulative.
Does say a significant or cumulative adverse effect upon the resource values, if I'm reading it correctly. Right?
Yes, so, but my point, so I think that could be, so for example, I could give you an example that, let's say there was a large number of docks in a certain area that adversely affected recreation boating, and then a property owner comes along and they're kind of the last one in the neighborhood to want to have the dock. They could make a finding of this cumulative effect.
Isn't that what that finding is? Project would have a cumulative effect on the overall water sheet?
So I disagree for two, well, it's what it says, Your Honor, but what I would argue is two things. Number one is if you meet all these criteria, how can the Conservation Commission say with any kind of credibility that it's going to have a cumulative effect? And secondly, the finding is insufficient under the law because the regulations are a subset of the bylaw. So in other words, it's like, and here I am talking to an appellate court, you've got your constitution, then you've got statutes, then you've got regulations. The further you go down the line, they have to be consistent with the enabling legislation. The commission is only empowered to deny a project for the reasons given in
And
the...
703-5A empowers the commission to deny a compliant project if there's a cumulative adverse effect.
I do agree with that.
Okay, so, I mean, let's say we agree with you that the finding is inadequate. Your remedy would be a remand, right, not a reversal.
Correct. I would agree with that. But again, I do want to kind of emphasize the point, Your Honor, that the bylaw, which is what created the conservation, in which was the legislative delegation given to them, sets forth 6 reasons why a project can be denied. One is failure to submit the information. One is failure to meet the design criteria. And then the catch-all is failure to avoid or prevent unacceptable significant cumulative effects. And so this gets to the point where any project in a wetland resource area has some impact. The commission could have enacted a prohibition. In fact, the town of Barnstable has under its zoning bylaw a prohibition in a certain area called a shellfish relay area. And there are other towns on the Cape where I practice. The town of Falmouth, for instance, prohibits docks, new docks, in velocity zones where waves crash during storm events, and in areas where there's significant shellfish habitat. The town of Barnstable did not do that, and so I see Your Honor's point that that sentence is there, but it must be read in context with the bylaw itself. And the bylaw says that you have to have unacceptably significant, and that's more than just...
Or cumulative effect.
But
so
the
unacceptable cumulative effect.
Agreed, but I believe the unacceptably significant applies to that phrase as a matter of statutory construction. In other words, all projects have impacts. And so if the commission were, they could just very simply say, oh, this has a cumulative effect, you don't get a permit.
I mean, I buy that unacceptable could apply to cumulative, but I don't see how significant could apply to cumulative. There's an or in between significant or cumulative.
Don't they both apply to the word adverse? Either a significant adverse effect or a cumulative adverse effect? It seems to me that's, I'm reading.
I believe that it does. That would be my contention, but I have one further response to Your Honor, too. The bylaw itself also says, for failure to avoid or prevent unacceptable, significant, or cumulative effects, where it is deemed the denial is necessary, and where no conditions are adequate to protect those values. And so the commission has authority to condition projects, and therefore they could have conditioned this. They could have said, make the spans between the piles longer so you have less piles. And forgive me, Your Honor, I forgot the basis for we're on the intellectual level here, but what was the finding that you said that was?
Cumulative effect on the overall water sheet?
A cumulative effect from what?
On the overall water sheet.
On the water sheet.
I'm not sure what that means. Maybe you can
I think
explain
what
it
that
to me.
means is the water sheet is the surface of the water. And that's where, again, I think if you can dig down into what was going on here with the commission in the regulation says there's a length limitation, and it explains that. And it says we need a length limitation so there's no interference with other uses of the water. And so if you meet that performance standard, then how can they come along and just say, kind of in a conclusory way, yeah, you meet our standards, but this one has a cumulative effect?
If you were in an area with an over-proliferation of docks, couldn't the commission deny any new application on that basis?
I would concede that point, Your Honor, but that's not what we have here. And the commission didn't explain that finding. I mean, so, and again, they have the right to make an outright prohibition. They didn't. And again, they set these rules of the road. The standards were met to the T in this particular instance. And again, it's for a non-motorized vessel. And so I'm running out of time, so I would leave the rest to my brief. Thank you.
We'll hear from the commission.
Good morning, Your Honors. May it please the Court? And again, for the record, Kate Connolly, Assistant Town Attorney with the Legal Department of the Town of Barnstable. Your Honor mentioned earlier 7035A, and I do want to address the Court with respect to the fact that that does say significant or cumulative adverse effects. Specifically, that section has a presumption that says when a proposed project involves the dredging, removing, filling, altering, or causing of a potentially adverse effect to an area subject to protection under the ordinance by the construction or enlargement of a dock, the Commission shall presume that the proposed activity will have a significant or cumulative adverse effect upon the resource values specified in Chapter 237, which is the Wetlands Protection Ordinance.
Okay, so first I want to pause because your brief says and, not or. So are we all in agreement it's or?
It's or, Your Honor. That's a typo.
All right.
And
what do you think unacceptable modifies?
I believe it unacceptable modifies both.
Okay.
So is the Commission's decision here based on unacceptable significant adverse effects or unacceptable cumulative adverse effects?
Different members mentioned both, but cumulative was definitely part of the discussion by most of the members, and they were concerned.
Does a majority need to agree on what the reasoning is?
Yes, a majority can issue an order of conditions under both the state act and the regulations at 310 CMR 10 and under the local ordinance.
What is the evidentiary basis for the finding of cumulative effect?
The fact that they've got it, oh, you mean in addition to the fact that it's in the ordinance, what did the commission find with respect to this?
What's the evidence in this record that supports the finding of cumulative effect?
The commission viewed the fact that this would be a permanent dock as the additional amount of time that it would be used would cause cumulative adverse impacts.
That goes to significant effect. I understand cumulative as used in the bylaws to mean
you take into consideration the other docks that are in the area and consider the cumulative impact of all of those docks. Is that not correct?
That's correct.
So what's the evidence here of that, the cumulative effect?
The testimony by one of the commissioners who has a doctorate in biologic oceanography has researched and reviewed many studies that led him to believe that a permanent dock put in this area that is high in shellfish, it was increased from an 8 value of shellfish back in 2001 to in 2011, I believe it became a 10 value when it was researched again. And one of the studies he cited was, and this is in my brief, but the 2013 Rapid Assessment Survey of Marine Species shows that marine introduced species are often found to be more prevalent on artificial surfaces than natural surfaces, and natural surfaces are typically seasonal piers versus which use more benign materials versus the permanent piers that use.
I'm sorry, let me try again. The 703-5 says, the commission will consider the impact of both existing docks and future docks with pending applications in determining the cumulative effects upon the protected resource areas. Is there any such evidence in this record? The impact of existing docks and future docks with pending applications?
Well, again,
that's what the bylaw says is meant by cumulative effect.
Yes, and the commission concluded, based on the research by the one commissioner who's got the degree in biologic oceanography and several of the others, that permanent docks promote the proliferation.
Any evidence in this record of existing docks in the area or future docks with pending applications?
Yes, there's testimony by the shellfish constable and also the shellfish biologist who went out and looked, in the area, looked at other docks, and they found invasive species on permanent docks, whereas they didn't find them. And this is cited in my brief in different parts of the transcript of the various hearings. They didn't find them on seasonal docks. So they were concerned that a permanent dock would have cumulative adverse impacts in terms of the growth or proliferation of invasive species. And they looked to a Superior Court case, Barnstable Superior Court, Ryan, in which the court found that although, and the court actually says, although it's new, the commission's interpretation, meaning the ordinance is new, the commission's interpretation is a reasonable interpretation of the fact that exotic species are a concern on permanent piers. And they were concerned that the permanent pier would reduce access for fin fishing in the water and boat-based shellfish harvesting and recreation, which is also an interest of the local ordinance that's not one of the values of the Wetlands Protection Act that makes their local ordinance more stringent. Exotic species and invasive species, even if they're not expressly mentioned in Chapter 703, are a concern, and this is what the court found in the Ryan versus Barnstable Conservation Commission case, that there's evidence of an increased risk to invasive species from a permanent dock that would not be a concern from a temporary dock. This is another situation where the commission concluded that the fact that there was a dock that had been there for 20 years was a seasonal dock. The fact that it did not create problems or cause problems was because it was seasonal. And there's testimony from the shellfish biologist that exactly said that. And if there are other questions, I'm happy to answer them, but I'm otherwise going to rely on my brief.
I want to just make this express. So I understand you to represent that the town is treating all applications for permanent piers in high shellfish areas the same.
They are. They review them on a case-by-case basis, but they look at
right, but if they're making a statement here about the materials for a permanent dock versus the materials for a seasonal dock, they're making the same thing in every single case.
Yes.
They're following the equal justice under law principle, right?
Correct. They're applying the ordinance fairly, using the entire thing, the preamble with all the presumptions, the regulations. They're looking at the entire thing when they review each project. And as I said, some projects are getting granted, some granted with conditions, some are denied. And typically it relates to if it's a high shellfish area.
So he argues that this Ryan case is not applicable here because the records are different, that in this case there was a rebuttal to the articles that were submitted by Commissioner, and I don't know how you pronounce this, Sampu, okay. So why is he wrong about that? Is it a different record than we had in Ryan? He's saying you can't keep applying Ryan, the commission can't keep relying on Ryan, because in Ryan, the records that the commissioner put into the record were rebutted in this case.
Well, the records in both cases are slightly different because they're different cases, so there's different testimony and different...
But in particular, that the expert testimony that was used in Ryan was rebutted in this case.
Right. In this case, in the Ryan case, there was the Ryan case is similar to this one. In this case, there was expert testimony, but it was rebutted. In this case, there was also testimony by the applicant's consultant, who's not an expert with respect to things like exotic species, and that was rebutted. She mentioned one study that she said was similar because of the climate. The commissioner, I believe it was Sampu, put in 6 or 7 different studies that he relied on, and the commission chose like a Falmouth versus, or Pacheco versus Falmouth. The commission found that two conflicting expert views, and in that case it was not that the applicant's consultant was an expert, but she cited a study. The commission chose to weigh much more heavily the testimony from the commissioner with the doctorate in biologic oceanography, as well as all of the studies that he referenced.
I don't have well, I was working on it, but I don't want to be distracted, the regulations up, but we're back to this non-motorized versus motorized situation. So if a particular regulation says it applies to motorized vessels, then it's limited to motorized vessels, right?
That's correct.
Okay. I know you say the commission can rely on the preamble. And I feel like in a different regulatory scheme, we have case law that says that. But do you have a case that says that?
That they can rely on the preamble? I'd have to rely on my brief. I don't recall the case, but it's basically the statutory construction. You look at an entire statute or regulation, you've got to consider all of the parts. And I can email the clerk with the specific case if the court wishes.
Thank you. Do you have any other? All right, thank you very much. We'll go on then to the third case, 2024 P 675, McFarland versus Barnstable Conservation Commission. Again, just in case anyone's listening to this argument, this case was argued among right after 673 and 674, and all are against the Conservation Commission, and we have agreed we can stop this time and go to the next case to allow a split, to allow council to have some experience arguing here, but no repetition.
Exactly. Members of the panel, may it please the court, Brian WAHL for the appellant in this case, and I appreciate the court's indulgence. I apologize for not calling the clerk in advance, but Attorney Troy's been with me for almost 2 years now, and she worked on all these briefs. I thought it would be appropriate if she could have a few minutes. And bearing in mind the court's instructions not to be repetitive, I'm going to be brief on this particular one. In this particular instance, what we're talking about is a brand-new dock. So the McFarland's own property that's proximate to the last 2 cases, it's in Osterville. They have a beach that they have an enjoyment of, And on the seaward side of the beach is a band of salt marsh that kind of impedes their ability to get to the water. So what they would like to do is to construct an elevated dock to get up and over the salt marsh out into the water. They similarly do not have the required depth at the length limit. And so what they're proposing is a non-motorized use of the dock. In fact, they have a unique set of stairs proposed that would allow them to essentially go out to a platform instead of a float. There's no float in this instance, and then launch a kayak and or a sailboat from that particular instance. And so again, at the risk of not being repetitive, the arguments here flow similar to the ones before. In this particular instance, the McFarland family hired a consultant who was familiar with the rules of the road and designed a dock that we contend meets all of the performance standards that the Commission has seen fit to adopt. Nevertheless, the Commission denied the project, and then the various reasons that they gave for denial are set forth in the findings, and I would pick up with some of those findings. So for instance, finding number 5, they said that the pier will reduce access for shellfish harvesting, which is therefore detrimental to recreational interests. And my argument is similar to what I made the last time. Is there's preamble that talks about adverse effects. There are performance standards that say that these minimize the adverse effects. And then in order to deny, there must be a finding of an unacceptable significant effect. And when you look at the findings, they just, to use an idiom, don't hold water, because when you compare them to the performance standards, you can see that the Commission is just reaching for straws to deny. So for example, reducing access to shellfishing, well, the regulations allow permanent piers if you meet the performance standards. So clearly the pier there will have some impact on access, but a boat can still move in and around the pier. And there's evidence in the record that if it's a shellfishing person who is with waders, they can go up to the edge of the pier, and with their rake they can reach underneath and get more than halfway, and then they can go around the other side and do the same thing. And so, and piers are recreational uses, so the town protects recreation. They have to look at it from all people that use the water sheet. Similarly, there's just a clear error in this particular decision. One of the reasons was for denying, it said that permanent dock owners run what are called ice eaters. For those that might not be familiar with boating, sometimes ice develops around the pier, and so the pier has a bubbling system to keep the water moving. In this instance, the consultant said, we won't use that. We're going to use a PVC collar. But nevertheless, the Commission denied the project because of running ice eaters. And there again is another instance where that could have been dealt with a condition. They could have said, we are approving you, but don't use ice eaters.
Wasn't the burden on the applicant to show that the alternative method would have been effective in controlling the ice formation?
Yes, and the consultant actually said that based upon a nearby marina that uses them, Oyster Harbors, which is just probably half a mile.
It was reasonably effective.
Exactly, that's what she said.
Why couldn't the Commission find that's not enough to show that this would be an acceptable alternative?
I would submit the Commission could have found that, but that's not what they found. What they found was that the dock owners will run ice eaters. That's what they did. They didn't get into those details that Your Honor's getting into.
Can I ask you, what relevance does an applicant's needs have in the analysis?
I don't think very much at all, Your Honor, and I think that cuts both ways. Clearly, the families that are appearing before this court today want docks. I wouldn't use the word need a dock, but they would like to have the dock. But the Commission sometimes gets into those kinds of analysis, and I forget now, excuse me, because after 3 of these cases, the record's about 1,000 pages. I think it was this one. If it wasn't, it was the prior one, where the Commission made a finding that said the costs involved and the inconvenience involved with the contractor taking a seasonal dock in and out do not justify the need for a permanent pier. And that's not in the regulations whatsoever.
Why isn't it implicit in the word unacceptable? So for instance, let's take this case, a construction of a new pier. If there's a finding that a seasonal pier would adequately meet the applicant's needs, let's just call it needs, and would have a less adverse impact upon the resource values than a permanent pier, that would make a permanent pier unacceptable. Isn't that implicit in the word unacceptable?
I would disagree with that, Your Honor. I think that the regulations are there, and if one can design a project that complies with those regulations, then there's that finding that says that you've minimized impacts. The commission gets a little, I'm going to say, sloppy in its analysis and does exactly what I think Your Honor is pointing out. There are a number of quotes in our brief, I think Mr. Sampu was one of them, that said, our job is to review these applications and determine whether there's a less impactive alternative. But that's not what the regulations say. And regulations sometimes do that. Like, for example, in the Riverfronts Act, an applicant that comes before must do what's called an alternatives analysis and make that kind of demonstration. That's not in these regulations. In this particular instance, an applicant is allowed to propose something and then make a case that it meets with the performance standards. And then our contention is if you make that showing, you should be, absent some other extreme example, that you should.
Let's say you have a project meets the performance standards. In what situation could the commission deny the project regardless based on unacceptable significant effects? Because you seem to be saying that if you meet the performance standards, that's it. The commission has to issue the permit.
I'm not quite saying that. I'm saying that there's a strong case that if you meet these performance standards, you're presumptively deemed to have minimized impacts. So there can be some other example that could come up, but I would make an argument that the commission needs to identify that and make some findings.
Can you give an example, concrete example today?
I'll try to come up with one. Let's say that you meet all the performance standards, but your dock is in rare and endangered species habitat, and despite meeting all the standards, you might have an adverse impact on a rare species. The commission might find that that's unacceptable. And therefore make a finding that even though you meet the standards, that impact on rare species is going to be unacceptable and significant, and you could be denied. But I think that the flip side of that, the corollary of that argument is that if you go to the efforts, and you must bear in mind, if I may suggest, these applications that come before, you can see from the record, the applicant hires consultants. They design things, they take bathymetry, they do a lot of work to show what the resource areas are and that the proposed project is going to meet all these standards. And I think if you do that, then the commission should not be able to say things like, you're going to reduce access for fishing, you're going to have an adverse effect on shellfishing. Those are just too vague and amorphous. I mean, all projects have some impact, and as I've argued before, they've identified what these adverse impacts are, and then they've set these performance standards for you to comply with. And so if they come up with one of those other reasons, it should be a valid, good, explained reason, not just kind of a willy-nilly, you're gonna have an adverse effect, because anyone can say that the project is gonna have an adverse effect.
Do you have and again, it may not be in the record, but I'm asking the question, do you have a view as to the agenda? Because you seem to suggest that there's an agenda, that these are agenda-driven.
We certainly have made the ad hoc argument, right, Your Honor. I have made that in the briefs, and I would rely on the briefs on that. I would also say one thing, and then I would like to yield my time. Sure. The other thing I think that kind of flows through all three of these cases is if you look at the record carefully, we have a State Wetlands Protection Act. I think all three of these projects were approved under the Act, but denied under the bylaw. And I make this point in the reply brief to this case, the McFarland cases. Our contention is that the commission sometimes, I think, gets comfortable in its position where it says, well, we're the town of Barnstable, we've adopted our own local ordinance. And there's plenty of case law that says under the Home Rule Amendment, towns can do that, and they can enact more stringent regulations. And none of that is debated. That's the law. But on a day-to-day basis, when applicants are appearing before them, you see in the transcripts and throughout these cases where they say, well, this is more stringent, we can regulate that, we can regulate that, we can deny you for this reason. But when you look very carefully, their reasons are not tethered to the regulations. They're going kind of off script on things like reducing access or adverse effect to shellfish when a person comes before them meeting every single performance standard that's met. And if I've answered the question, Your Honor,
Yeah,
I'd like to
thank you.
yield the rest of my time to Attorney Troy.
Good afternoon, Your Honors. May it please the Court. Clodagh Troy on behalf of the McFarlands. So again, not to be repetitive or redundant as far as what's been said, not only in this case, but in the previous two as well, I just wanted to touch a little bit more on the standards that the Commission was applying, or the lack thereof, I guess. And one thing I just wanted to direct the Court, there was discussion earlier about and versus or as far as the significant and or cumulative effect. Section 237-11, which is the burden of the applicant, does use the word and, so it does appear differently in different places of the ordinance. So Attorney WAHL mentioned earlier.
I'm sorry, you said 237-11?
Yes, Your Honor. And that is the burden of the applicant, or burden of proof, I'm sorry, I believe is the section title. As Attorney WAHL alluded to earlier, there appears to be some confusion among the Commission members themselves as far as what standard they are applying to these projects. I think it bears repeating, but the direct quote from Commissioner Sampu was, "Each project before us is decided on its own merits," and we agree with that. But then he went on to say, "It is our responsibility to assess whether a less impactful alternative exists to the one proposed by the applicant." And we would argue, Your Honors, that respectfully, that is not the responsibility of the Commission. Their responsibility is to apply their regulations as enacted, because that, of course, is what creates uniformity, predictability, things of that nature.
If there's a less impactful option out there, why doesn't that make the adverse effects of this project unacceptable?
Because I think, Your Honor, there will always be a less impactful alternative, and then if you cycle that back to its extreme, then no dock would ever be approved, because of course no dock, no structure is going to be the least impactful alternative. So to have commissioners believing that they're imposing a standard such as less impactful alternative, their job is to assess the project as proposed to them, and to analyze that as far as compliance with the regulations that they have enacted, which they had the authority to do under the ordinance. So all of those tie together. And again, I think that kind of came out also in finding number 13, which reads, "Unless evidence is presented that a permanent pile pier will lessen environmental impacts, regulations make it clear the benefits of a seasonal dock." And that is, I would posit, not what the regulations say. There is no burden for applicants to demonstrate that a permanent pile pier will lessen environmental impacts. There is the presumption that sometimes those impacts, or the presumption of those impacts may be more easily overcome for seasonal versus permanent, but there is no restriction on permanent piles. There's no mandate for temporary piles in the regulations as enacted. And lastly, just finishing up here, as far as reading the preamble as a whole, and that presumption contained therein in section K, it's been discussed before kind of how the ordinance and the regulations relate to one another, but as far as the preamble and reading it in context, you have the ordinance which authorizes the Commission to enact regulations. The Commission did that, section 703. The preamble sets forth various impacts that the Commission is concerned with and how those might impact resource areas which have been jurisdictionally granted through the ordinance. And then section 703(1)K says that if you comply with the performance standards, then you have minimized those impacts. So I think, again, it's just important to emphasize that those performance standards should be viewed as what the Commission itself has already decided are tolerable limits. For example, they cite the length performance standard as invoking kind of a recreational interest in the decision without finding noncompliance. And again, it's a quantifiable standard, it's 100 feet, and in this case, the proposed dock was nearly 20 feet below that. So it objectively complies with the standard. So, and with that, we will rest on our papers.
So if there was a clear error about ice eaters versus a different way, the PVC collars, does that mean we remand?
Potentially, Your Honor, I think that would be one way to annul the decision as written, because it would lack that substantial evidence in the record, that factual basis. So as a matter of fact, I think in that case, that would be an issue, and to remand with specific instructions to abide by the regulations and apply them as enacted.
Any other questions? All right, thank you very much. We'll hear from the commission.
Thank you, Your Honors.
Thank you, Your Honors.
Good morning again, Your Honors. May it please the Court. Kate Connolly, Assistant Town Attorney for the Town of Barnstable. I just want to address a few things that my brother said earlier. First of all, the fact that these I'll just focus on this project. The fact that it was granted under the Act and denied under the local ordinance, it doesn't make any difference at all. The DEP has the authority to administer and enforce the Wetlands Protection Act. Only the Conservation Commission has the authority, it has dual authority with DEP to apply the State Act. And there are many cases cited in my brief, but one in particular, Parkview Electronics, which I cited, says that where a local Conservation Commission concludes that a project meets the requirements of state law, it introduces no legal dissonance and violates no principles of state preemption. So it's quite common that Conservation Commissions will grant an approval to a project under the State Act and deny it under the more stringent provisions of the local bylaw or ordinance. If those stringent provisions, and this, I thought this was obvious always, but the Healer Court finally made it obvious, those stringent provisions have to actually be part of the proposed project. You can't, for example, you can't deny something that, because you regulate the buffer zone if the project isn't in a buffer zone. Secondly, with respect to the discussion of ice eaters, there was quite a bit of discussion amongst the commission about that. And although the applicants said that they had proposed PVC collars, polyvinyl chloride, the commission, and that is to prevent ice formation, the commission found that that was not acceptable enough. And the applicant's consultant even said that they are only minimally, that wasn't the language she used, but something like most of the time they're effective. And the commission felt that that's not adequate. And the commission also concluded, after much discussion and testimony by Commissioner Sampu, who's the one with a degree in biologic oceanography, and citing many, many studies, including from the Division of Marine Fisheries, he said that pilings provide structure for colonization of invasive species, as well as increasing potential for trash and wrack accumulation. There was testimony from another Conservation Commission member who installs piers and docks and has quite a bit of familiarity with them. And again, not to repeat things from the previous arguments, but this applies to all of the previous arguments as well. He's gone out and observed that seasonal piers don't have invasive species growing on them the way permanent piers do. So the other comments from the applicant about how they may not need to use ice eaters, the commission also disregarded, because permanent piers
May I ask then on that issue, because I think you said earlier there are some applications that are allowed, some are denied, but with some conditions. From what you're saying, if invasive species are an issue on all, presumably, permanent, I'm losing the word now, but you get my drift. It's all permanent, then wouldn't that mean that by definition, any request or any project that involves some permanent structure is denied?
It also depends on the environment and the exact part of the body of water, whether it's a shellfish area or not.
Right, but we're assuming that it's a high-impact shellfish, lots of shellfish. I'm talking invasive species-specific denials. Wouldn't that apply to virtually, or not just virtually, to every
It applies
project?
to almost all permanent piers, but again, it really does depend.
That was the word I couldn't find,
Piers,
strangely enough.
piers or docks. But it also really does depend on the environment. And these three cases are all in the same neighborhood, in the same gated community. There are others, the one I mentioned earlier when I was distinguishing that one in the Centerville River that's cited in one of the cases, that's Bergeron versus the town of Barnstable. That's in a completely different area. It's a river, it's not salt water. So this is why the commission does have to look at the environment where the proposal is and not just whether it's seasonal or permanent. They've permitted some permanent docks as well.
Maybe this is unfair, but I'm going to ask it anyway. What's the justification for allowing the project in the first case and not the second case? If they're in the same area, they both proposed to change a seasonal pier to a permanent pier. So why was one allowed and one denied?
The first case was JMS Holdings, the second one was Martin. And the concern with the first one was the depth that they wanted to, that was not an issue with.
That aside, the proposal to change the seasonal pier to a permanent pier was allowed in JMS, and it was denied in Martin. Can you explain why, the difference between the two projects?
I believe that, I'm forgetting now what the size of the Martin Pier was, but I believe the two projects were very different in terms of what they were using for the structure, as well as the depth issue that arose. The JMS pier has been there for about as long as I believe Martin has had their pier for a long time as well. But, and my brother can correct me if I'm wrong, but the concern the commission had in the first one was that there's been a pier there for a long time. They'd allow it, but not at the depth that they wanted to allow boats to be attached to the end of it.
Can I ask, in JMS, although I take it that the permanent structures don't go into the water where invasive species might grow, is that right, or is that wrong?
The piles do go into the water, but it's more the benign materials of the seasonal piers that do not attract invasive species, whereas the materials that are used for permanent piers do.
Understood. Okay, then to Justice Shin's question then on JMS, why was there no, I didn't see any discussion of invasive species there and concerns regarding invasive species? That they okayed it, basically, notwithstanding presumably the same species, since it's kind of the same water.
It would be a concern.
Go ahead.
It would be a concern there as well. They just didn't focus on it as much because they were much more concerned with the depth issue.
Okay.
And getting back to this case, my brother mentions that.
Can I just follow that then? Do you understand to the point, I guess, that Mr. WAHL is arguing, though, that it seems like a bit of maybe of a moving target, and so for folks who want some standardized, understandable, consistent approach, so they know what they're getting when they walk in the door, if on one thing we're saying, oh no, that's got invasive species problems, and over here we're saying, well, it's the same thing, but we're not really that concerned about invasive species. How does a person who's proposing a project process that in terms of what the commission is going to do?
Again, it goes to the location. These are all high shellfish, but
But I think you said all these three locations at least are pretty much in the same bay.
They
and
are.
So would have the same water and the same, I mean, they may have slightly different shellfish concentrations, I would imagine. But on the issue of invasive species, if that seems to be a focus on these last two.
yes, it was more of a focus in Martin and in the current case that we're talking about, McFarland. And the burden of proof, again, it's really important to note that the burden of proof is on the applicant. If the commission feels that there are, or concludes based on the testimony provided by their experts, and that includes people who are members of the commission, but also the shellfish biologist and the shellfish constable, that there are going to be adverse impacts and that the applicant has not provided enough information to refute that. In this case, stating that there's an ad hoc agenda, there's been nothing, they cite Fieldstone Meadows, but in that case, It was a written policy. It was not, as my brother correctly stated, there's an order, statutes, regulations, in municipalities, the ordinance or bylaw governs over the regulations, and a policy is completely less weight than those two things. So in Fieldstone Meadows, there was a policy that the commission followed, and the conditions that they imposed on a project that was appealed, based on that policy, it was something that was not written in their regulations or their bylaw at all, whereas in this case, the applicant doesn't point to anything that's supposedly showing an ad hoc agenda, rather just states it, and as the court found, it's easy to state that, it's much harder to prove it. The commission here has been very careful since it first adopted, except for that one case where the court found that they had a bias, if you will, against peers. The commission has been following the provision that says they've got to review projects on a case-by-case basis, and they expect the applicant to provide reasons, studies, engineering, whatever they need to do to show that there are not going to be adverse, either significant cumulative or significant adverse effects on the project. It's not the commission's burden to design the project or to tell the applicant what they should use. The applicant in this case did say that they would use PVC collars. The commission found that to be inadequate, and they denied it based on those concerns. The applicant does try to shift the burden illogically at one point, which we think is clear in the brief, and there are presumptions in the preamble, as we've discussed. The commission needs to look at the presumptions as well as the regulations and read the whole thing as a whole. And in this case, Chapter 703-5A, which, as I said in my brief, I did say or, significant or cumulative adverse impacts. That's a presumption that a permanent pier would have significant or cumulative adverse effects on the protected interests. And the appellant's burden is to overcome that. The appellant simply stated that they met performance standards, and that isn't enough. They've got to show with evidence how they overcome each of the presumptions. If there are further questions, I'm happy to answer them, but I would otherwise rely on my brief.
Thank you very much. The case is submitted. Well argued on both sides. And with that, we are not quite adjourned. There'll be an argument here at 2 o'clock for a case that did not get heard last week. So, but I thank our court staff for all your work this morning.
All right.